Good evening. I'd like to welcome you to the City of Green Council meeting. Today's Tuesday, July 9th, 2019. Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Will the clerk please call the roll?
Mrs. Babbitt.
Here.
Mr. Dyer.
Here.
Mr. Humphrey.
Here.
Mr. Shaughnessy.
Here.
Mr. Spate.
Here.
Mr. Yergin.
Here.
Mr. Young.
Here. The next item on our agenda is a council study session. We have one item. It's the approval of the June 25th, 2019 regular meeting minutes.
Move to approve. Second.
I have a motion and a second for the approval of the June 25th, 2019 regular meeting minutes. Is there any discussion? All in favor?
Aye.
Motion carries. I should have asked, is anyone opposed? The 25th, we're all here?
Motion still carries.
Motion still carries. Okay, the next item we have is the public report. We've got a couple folks signed in to speak this evening. I think most of you are here for our public hearing, so if you're signed in to speak for that, you could probably hold your comments until after the public report, but I'll call you up here anyway. The first one we have is Pat Karleski.
Pat Karleski, 3878 Greenfield Road. I would like to thank the city, the service director, and everybody else who was involved for the prompt action in our neighborhood when the big tree fell down and took down the wires and the utility poles and everything. I was so heartened to pull out, as I was trying to pull out of my driveway, to see that big old emergency response truck come by with what I'm sure were all the important goodies in it. I didn't even know we had such a thing. But again, the response was wonderful. Thank you. And I would also like to thank the chief and our fire chief. Clumsy me, I needed to install a smoke detector in my house on the basement staircase, on the ceiling. And it scared even me, the thought of standing on a step stool and trying to install this thing above my head. And he found a very professional, courteous firefighter to come to my home and install that thing for me. And Miss Smoley and I were just talking, we're both single ladies. Somebody who would like to start a business, single ladies, older ladies like ourselves, we need people to do chores. You can't hire somebody to clean out your gutters. You can't hire somebody to install a fire detector, okay? So if anybody wants a business idea, probably between the two of us and in our neighborhood, you'd get a lot of business. Thank you.
Thank you, Mrs. Karleski. The next person signed in to speak is Mr. Joel Helms. Good to see you, Joel. Haven't seen you for a while.
4977 Maslin Road. Article 6, change administrative to city departments. This is your the charter amendment that you guys are allowed to change on your own, your charter things. I believe changing an administrative to city departments leads to a possibility, a high possibility, of error in misinterpreting the law director's purpose, where he's supposed to be representing the city as the people are the city, and this automatically puts, well, guess what? It's the administration now is defined in this particular article, administrative departments. I think this is can lead to some issues. So please consider that and its ramifications. Thank you.
Thank you, Mr. Helms. Is there anyone here else this evening like to speak? Okay, we'll keep moving forward. The next item on our agenda is a public hearing. We've got quite a list of things we're going to hold a public hearing on. So for that, I will turn the gavel over to Mr. Yergin to run those hearings.
This calls to order the public hearing on the charter review amendments.
which I will read in a few minutes. But by way of just a little bit of introduction, charter review occurs every 7 years. The mayor, by our charter, section 9.2, is required to appoint 5 electors of the city to serve on the commission. Those electors are seated in the front row behind the podium, and they are from my left to right. The vice chairman, Attorney Vivian Duffrin, Ms. Sherry Newbert, Attorney Ted Malo, Attorney C.J. Meager, and a chairman of the committee, Susan Allen. By our charter, they are required to hold public meetings, which are recorded and made a part of the permanent proceeding for the city of Greene. They have met from January the 23rd to June the 11th. Based on the record, they have met 13 times for a total of nearly 22 hours of meeting time during that time span. That does not include time that was spent off the record drafting and redrafting provisions, does not include time dealing with outside counsel who gave extensive advice and spent a lot of time with them. And as someone who observed that proceeding, I just want to say, on behalf of the community, thank you for your efforts. We appreciate your work. This is only one attorney's perspective, but I've argued in front of lots of judges. I've argued in front of 3 judge panels in the Court of Appeals. And I would say that the legal acumen, the thoroughness, your willingness to get into the weeds and do the hard work of charter review, I would compare that to any judge, any tribunal that I've argued in front of as an attorney. And you've served us very well, and I appreciate it. The process involved really reading and reviewing and considering every single word of our city charter. That's a normal process, and it's done every 7 years. But this year, the charter review was unique in that it came in the wake of the passage of issue 14 that converted the appointed law director position, of course, to an elected position. And one of the big challenges that our commission faced was retrofitting our charter for an elected law director, because it was based on the premise originally that our law director would be appointed. As a result of your work and your efforts, you've put before us 14 proposed amendments. Our consideration is simply to determine whether those go on the ballot. Normally, when issues are presented to council, we vote on them by majority vote. This is a different animal. By our charter, we will put them on the ballot for residents to vote upon unless 3/4 of the members determine otherwise. So there's built into the charter a presumption, basically, that these matters will go on the ballot. And before I turn this over to the Charter Commission, I want to talk just one moment about the procedure as to how we'll carry on the meeting. There are 14 different issues to talk about. So what we've done is we've asked the Charter Review Commission to step forward and give us a summary, which I think will answer many of the questions that the public and council have. And then when their presentation is done, we'll hold the questions and try to deal with them in what I hope is a reasonable order. So I will call each particular resolution to the floor. I'll read it into the record, and then we'll allow council to comment on it and allow members of the public to comment on each one as it's called in, so that we can have an orderly discussion for each one. With that, I'm going to turn the floor over to the Charter Review Commission, and I understand that you've designated some people to speak on your behalf.
Hi, I'm Sherry Newbert, 2766 Park Place Drive, and I am going to take first 6 or 7 items through, and then I'll turn it over to Ms. Duffrin, who will take section 6, and then I'll be back up to complete a few more. So she and I will be trading off these sections. As Mr. Jurgen mentioned, we've prepared a summary with the idea that this summary will provide additional context and clarification around these particular items. So I'll start by sharing the thought process around 3.1. and specifically a little bit of the background and the thought process. So first off, 3.1 deals with the term of office for mayor. And this particular item was brought to us by resident Steve Braswell, who brought to the commission's attention that the absence of language on how to count partial term against term limits was missing from our charter. And so after much discussion and input, we recommended to count any partial term lasting more than 2 years as a 4-year term against the limit.
And Ms. Newbert, for the people following along, you're referring to 2019 R56. That's the amendment to section 3.1, just so people can
Okay. All right.
follow along.
Okay, very good. Do you want me to reference those as we go
That would be
here?
helpful.
Sure. Okay. Yes, absolutely. So again, we found that this language was missing in the charter for both mayor and council. And so our recommendation is the same for both mayor and council. And these recommendations are reflected in 3.1 and 4.1, with 3.1 being the 2019 R57. The next topic is the qualification, deals with the qualifications of the mayor. Our recommendation in this section seeks to clarify the intent that anyone elected or appointed as mayor should have been a resident of the city of Greene for at least 2 continuous years immediately prior to being elected or appointed. So again, the thought process here was that we wanted to have a mayor who had been a resident of the city of Greene for at least 2 years immediately prior to becoming mayor versus simply having resided in the city of Greene at some point in the past. And that was the thought process for that particular recommendation. So that recommendation is regarding 3.2, 2019 R58, and that recommendation again is the same for both mayor and council, and you'll see those reflected in 3.2 and 4.3. The third item is powers of the mayor, 2019 R59. This change seeks to modify and append the charter language on the mayor's power to appoint and confirm directors and employees. The first sentence of this change limits the mayor's powers to appoint a director of law, but it has no impact on any other directors or employees. The appended 5 new paragraphs deal with acting and interim appointments and have been added following a recommendation from Councilman Dyer and much discussion among the commission. So previously, no language existed in the charter to explain how an acting and interim appointments are made, their duration, the role that the mayor or the council plays in each. This new language states that acting appointments shall expire 90 days following their effective date, and that no council approval is required to make an appointment. However, no extension of an acting appointment can be made without the majority vote of council. For an interim appointment, which shall expire in 6 months following their effective date, the same requirement applies and is true as with acting appointments. That is, no council approval required for the appointment, but no extension of the appointment may be made without the majority vote of council. The next change is Resolution 2019 R60, and that is 4.1, the term of council. And again, this is previously mentioned as resident Steve Braswell brought to the commission's attention the absence of the language on how to count partial terms against term limits. Again, after much discussion and input, we recommended to count any partial term lasting more than 2 years as a 4-year term and against the limit. So, as we said, we found this language was missing from our charter for both mayor and council, and our recommendation is the same for both mayor and council, and these recommendations are reflected in 3.1 and 4.1.
Ms. Newbert, I think that when you're referencing the 2019, that was for 59 and not 60. I think that
Oh.
the numbers that you're referencing are just one
Right
ahead.
below.
So
Thank
you'll
you.
just have to subtract one for each.
Thank you.
It was probably an old list.
Okay. Oh, I see, they're misnumbered on this document. Gotcha, okay. Thank you for pointing that out. So looking at 4.3, let's just to be clear, yeah, 4.3, 2019 R61.
R60.
Oh,
Ms. Newbert, Mr. Jurgen, would it be helpful if maybe you read them in and then she gave us a summary of each piece?
Sure.
I mean, you don't have to, this is your hearing, but if that would help us kind of follow along there, that might sort through this a bit.
We'll tag team it.
okay.
So 2019 R60 is the resolution to amend Section 4.3 of the Charter of the City of Green to require each council member be a resident of the City of Green at least 2 continuous years immediately prior to each council member's election or appointment and declaring an emergency.
Yep. And as previously mentioned, with regard to 3.2, our recommendation in this section seeks to clarify the intent that anyone elected or appointed as council should have been a resident of the City of Green for at least 2 continuous years immediately prior to being elected or appointed. And again, the thought process is that we want our council members to have been residents for at least 2 years immediately prior to becoming council members versus simply having resided in the City of Green at any time in the past.
2019 R61, that's next on your list. A resolution to amend Section 4.6 of the Charter of the City of Green to provide for council to fill vacancies that occur between a November general election and the end of December of that same year and declaring an emergency.
And this particular item was meant to provide clarification for a situation that occurred in the 2011-2012 time period when Mr. DeVitas was appointed to the House after already being elected to the City of Green Council. So the idea here is that in the event of a vacancy that shall occur in the office of a council member between the November general election and December 31st of that year, the time period to fill the vacancy shall be told and therefore not to begin to run until January 1st of the following year. So what does that mean? That basically means that this language proposes that vacancies occurring during this limited time period would be filled by the new council versus the outgoing council. So that's the purpose for tolling that time period, and then vacancies that become vacancies that occur will be filled by the new or the incoming council versus the outgoing council.
2019 R62 is a resolution to amend Section 5.4 of the Charter of the City of Green to set requirements for nominating petitions for the office of the Director of Law and declaring an emergency.
And this language was appended to Article 5.4 as required by Issue 14 to be consistent with the already in place process dictated for nominating petitions for the mayor, and which required the same number of signatures of council members at large. So this is the recommendation of N not less than 75 nor more than 225 for the office of Director of Law. So again, part of Issue 14 consistent with the thought process with council members at large.
2019 R63 is a resolution to amend Section 6.2 of the Charter of the City of Green to be consistent with Section 3.3D, which requires persons appointed by the mayor as directors of city departments to be confirmed by a majority vote of the members of council and declaring an emergency.
And I'm going to turn it over to Ms. Dufferin for Section 6.
Should we have questions now on those ones?
Good evening, everyone. Vivian Dufferin, 2821 Crow's Nest Circle. I am tasked with discussing Article 6. I tried to jot down quickly the resolution references. I think I have a few minor points to discuss that may not tie into a specific resolution. I just wanted to point out, first off, 6.1, which I don't think is tied to a specific resolution. The title of Article 6 in our current charter is Administrative Departments, and that lists our current departments and directors, including the Director of Law. We did make a title change, or we recommended a title change to City Department rather than Administrative Department, because we felt that Administrative Department implies that the department heads are appointees or employees, and so we chose the term City Department. That wasn't really necessarily a substantive change, but I did want to bring that to your attention. And then we did have some discussion in Article 6 about should we remove Law Director from Article 6 entirely and create a new section, a new article for the Law Director, but in the end we decided just to amend our existing Article 6, leaving the Law Director in and adding language to cover the issues that arise with making it an elected position. So I think the first resolution, if I have these right, would be 2019 R63. Is that right, Rocco?
Yes.
Okay, and you already read that?
Yes.
So this is just addressing the qualifications of the other directors, not the Law Director, confirming the current language that the Law Director will determine the qualifications of the other directors, and that we deleted the portion about the mayor determining the qualifications of the Law Director, since we obviously have the election process. And our other change in 6.2 was to conform with Section 3.3D of the existing charter, that the director is appointed by the mayor, so again, not the Law Director, requires the majority council vote to appoint, and the removal by 2/3 vote. Section 6.3, 6.5, 6.6, 6.7, those were the directors of finance, planning, safety, and service, were not changed. We did not recommend any changes to those other than some minor wording changes that did not impact the substance of the sections. So then we go to 6.4A, and that would be Resolution 2019 R64.
Yes, a resolution to amend Sections 6.4A and 6.4C of the Charter of the City of Greene to establish the current requirements of qualifications for the position of Director of Law and declaring an emergency.
So with regard to 6.4A, the qualifications, starting with that, our recommendation was to maintain current language for the person that will be elected to this position in November, due to the timing of the voting for our proposed amendments and the individuals running for Law Director at the same time and on the same ballot. It was not feasible to make any changes prior to that, nor could that have been accomplished. So our recommendation is to maintain the current language for the persons that are running for office this November. And to recap on that, our current charter language, which has existed for years, requires that the Law Director be a licensed attorney and that he or she have a minimum of 5 years employment or public practice experience in municipal and/or other governmental law. Also, with the addition of the issue 14, of course, they have to be a resident and elector of the City of Greene. Going forward, so this would be individuals that are first elected after Jan 1 of 20. So again, this is not impacting the people, the person that is elected in November. This is only for candidates that are first elected after 1/1 of 20. We kept the current language in place. We defined the employment or public practice experience in municipal or other governmental law, and we did this for a few reasons. First of all, the Ohio Supreme Court has held that our language is vague, and this was a decision that came out not with respect to the City of Greene, but another city dealing with identical language. And the Supreme Court said that in order for that language to be enforceable, that terminology of public practice experience in municipal or governmental law has to be defined. So we did define it. Again, this will be going forward after 1/1 of 20. And what we decided was to recommend to you that the public practice experience in municipal or governmental law is defined as experience either as a director of law, as an assistant director of law, or a substantial equivalent for the state or one of its political subdivisions. So that would include cities, counties, townships, school districts, nearly every political entity that is smaller than the state is considered a political subdivision. Or, in the alternative, the candidate could have the substantial equivalent experience as an attorney representing the state or one of those political subdivisions in civil matters. So we did specify that technically criminal prosecutors are representing the state of Ohio, but that was not the type of experience that we were looking for. We were looking for someone that has represented cities, townships, counties in civil matters. So we did define that, and I just want to make clear the intent in the charter has always been to have a qualified law director in terms of relevant experience. There was no indication to us from the voters or otherwise that simply making this an elected position that our citizens don't want to continue to require those qualifications. But in order to require those qualifications going forward, we had to define them with more specificity. So it was not our intention, and we did not change the language, but we just further defined it to make it legally enforceable going forward. Our concern was that since this is a one-man show, so to speak, we don't have an entire law department. We have one law director, one person who has to know a wide variety of very specific law, that we did not want our law director learning how to be a law director at the expense of the city of Greene and at the city of Greene's time. So concerns that we heard or questions that were raised is will we have a large enough pool of candidates? What happens if we don't have candidates? I think that's very unlikely given the turnout of candidates that we had for the election that we're voting for in November. But if there were no candidates, or if an elected law director stepped down midterm, there would be a vacancy, and city council would have the option within that 45 days to fill that vacancy. And that is the only time that the mayor would fill the vacancy is if city council didn't act, or of course the mayor could fill it on an interim basis or a temporary basis. We also added language, I think I'm still in A here, yeah, 6.4A, that the law director not be employed by the city and in any other capacities, and that they hold no other public offices, so they're not an elected position elsewhere or here. We added a certification of hours worked requirements if council requested that the law director could be required to certify that they're complying with the number of hours that the position requires per city council's enactment. We also clarify that the number of hours required for the position, the benefits and salary would be dependent on council and set by council. Section B, powers and duties, we left the same. Section C, Rocco, is that a separate resolution, or am I still on
No, I think
R64?
you're still in 64.
Okay. So the election and term of office, let's see, the current issue 14 language, we recommended deleting the reference to the law director representing the people of the city of Greene, and city council. That was in the initiative petition. We felt that there was an inherent conflict with the law director representing all of those entities and individuals, and that it was a legal and factual impossibility to do so. So therefore, we changed that language to simply state that the law director will represent the city. We specified that the language in issue 14 said in accordance with ethical rules, and we just specified the Ohio Rules of Professional Conduct, which is where the ethical rules are found for attorneys. Term limits, Rocco, we're still on the same one, right?
I believe we are.
Term limits for the law director position, Consistent with the initiative petition, would be a 4-year term with two terms max. We did have some discussions on the merits of a term limits for this non-policy-making decision. However, in the end, we left that language in, consistent with the issue 14 initiative. We clarified for the law director, again, this would be different than for council, that a partial term does not count against the term limit. So if we have a vacancy midterm, that if somebody steps up to fill that vacancy, that is not going to count as a term or a partial term for that candidate. In terms of primaries, again, this would be consistent with issue 14, no primary votes unless there's 4 or more persons that have pulled petitions for law director. That's consistent with issue 14 language that says it's nominated in the same manner as the mayor. And under 5.3, the mayor only has a primary if there's 4 or more candidates. Okay, then we go to vacancy, which is
6.4D, and that's a new resolution. So 29R65 is a resolution to amend section 6.4D of the Charter of the City of Greene to provide for filling a vacancy in the office of the Director of Law and declaring an emergency.
So this is a new section necessitated by the election of the law director. What happens if we get a vacancy in this elected office? Consistent with issue 14 initiative language, we recommended that vacancy be filled with approval of 3/4 approval of council. The 3/4 was specified in the initiative petition. Council would fill the vacancy between 30 and 45 days. After it occurred, after the 45 days, then the mayor could make an appointment. The mayor can also select an interim law director if the incumbent is not planning on returning, or an acting director if the incumbent is planning on returning after a leave. And we do have time periods, I believe that was addressed previously, the 90-day max for acting and a 6-month max for interim without, unless council extends that. We do have language in there that the acting or interim does not have to be a resident of the city of Greene. Our thought process behind that was that if a situation arises where an unexpected vacancy occurs, that the city will be in need of a law director within days or a week or 2 in order to continue to conduct city business. And so with little advanced notice, we didn't want to restrict the mayor for choosing a resident necessarily. But again, this would only be on a temporary basis and not a permanent situation. A new appointment does have to be a resident and does need to meet all those requirements in 6.4A. Let's see. Applicants for the Director of Law to fill the vacancy, they would have to submit a letter of qualification and a petition signed by a minimum 75 electors, and that's in existing, that's in the other articles as well. I think that's, then I'm covering Article 8, Finance and Tax.
Yes.
Is that
2019 R66, a resolution to amend section 8.3 of the Charter of the City of Greene to include a credit for income tax paid to multiple municipalities and/or to a joint economic development district and declaring an emergency.
Again, this section just pertains to residents who live in the city of Greene and work elsewhere and pay city taxes elsewhere. The substantive changes that we added to that is to add a JED, a Joint Economic Development District. A Joint Economic Development District is, I guess, a geographic area that's usually created by political subdivisions, and they can assess local tax. Like an income tax, a municipal tax. So it's possible that we could have a resident that is working in one of these JEDs and paying municipal tax to the JED. So we wanted to include them and treat them just the same as if somebody was working in another city or somewhere else that collected taxes. We didn't change the substance of it, which is that the resident will pay no more than the higher of the 2 tax rates, that being Greene's tax or the tax rate of the municipality where they work. That was not a substantive change. We just tried to rework that language because we did not think that the existing charter was very clear on that point. And I think that is it until Article 12. I'll be back up after that.
There's Article 9.1 changes. Did you address that?
Yes.
Okay, thanks.
Sherry has those.
So I'll address 9.1 and 10.1.
Yes, 29R67 is a resolution to amend Section 9.1 of the Charter of the City of Greene to expressly reserve to the city the right to dictate ballot language for all proposed charter amendments and declaring an emergency.
Yep, absolutely. So here, we added clarifying language, reserving to council that it is council who has the right to dictate ballot language for all proposed charter amendments versus what might be proposed by some other entity, such as the Board of Elections. So based on our review and discussions with legal counsel, we believe that charter cities, such as the City of Greene, have the legal authority to dictate such ballot language when that authority is reserved in its charter. So hence our recommendation to make that authority as a reserving to council this right. Our recommendation is to apply the same for charter amendments and initiative petitions as reflected in 9.1 and 10.1.
10.1
Oh, before we
is
go there?
contained in 2019 R68.
Yep,
It's time
and-
to talk about that.
Yep.
A resolution to amend Section 10.1 of the Charter of the City of Greene to provide that the city expressly reserves the right to dictate ballot language for all proposed initiative issues and declaring an emergency.
And I did have one more point to note on 9.1.
Please.
Sorry about that. We also added a paragraph in 9.1 stating that in any ordinance placing a proposed charter amendment on the ballot, council may prescribe a brief summary of the same, which, if prescribed, shall be accurate, not misleading, and shall be without material omission or arguments. So council may dictate that summary language so prescribed also be placed on the ballot. Again, it's at council's discretion.
And in reference to 10.1.
And then in reference to 10.1, the initiative, again, as proposed previously with the charter amendments, we recommend adding that clarifying language, reserving to council the right to dictate ballot language for all proposed initiative issues being placed on the ballot versus, again, what might be proposed by some other entity. And again, this is our recommendation that the city reserve to council the authority over ballot language for both proposed charter amendments and initiative issues as reflected in both 9.1 and 10.1 respectively. Thank you.
R66.
I think we're at 2019 R69 is 12.8.
I'm sorry, 69. Okay, yes.
A resolution to amend Section 12.8 of the Charter of the City of Greene to provide for the removal of the Director of Law and declaring an emergency.
So Article 12 of our current charter addresses removals of elected officials, so we needed to add language to cover the removal of the elected Director of Law. And our current language would allow the Director of Law to preside over his own removal proceedings. So since we couldn't have that, we changed it to state that for the Director of Law who is being removed, that special counsel engaged by the mayor would preside over that process. With the special counsel engaged by the mayor with the approval of the majority of council would prosecute the removal of the law director from office if that became an issue.
Very good.
That's it.
Thank you, Ms. Dufferin and Ms. Newbert, for that summary. I think that was very informative. At this time, what we'll do is go back, starting with the lower numbers, and call the issue for a discussion by council and for any questions or comments by the public. I'm going to try to do this systematically so that we're not conversing about 14 different subjects at once. We'll focus on one at a time. I'm assuming there's going to be several that they're technical and don't propose a major change. There won't be a lot of discussion. And there's others like R64 and R65 that are really the bread and butter of the issue 14 sort of synergy with our current charter. So we'll start with,
Councilman,
Yes, sir.
you do want to read in 56 through 59,
Yes.
I believe, too.
and I'll
Okay.
do that
Thank you.
presently. Thank you, Mr. Chris. As members of the public come up, we do want to try to keep this moving in an efficient and orderly manner. So we're going to try to adhere to the 3-minute mark for folks when they address council. 2019 R56 is a resolution to amend Section 3.1 of the Charter of the City of Greene to limit the mayor to serve 2 consecutive 4-year terms with partial terms lasting more than 2 years, counting as a 4-year term, and declaring an emergency. I would point out that there is a companion, and that is 2019 R59, that essentially has the same amendment as it applies to council. 2019 R59 is a resolution to amend Section 4.1 of the Charter of the City of Greene to limit council members to serving 2 successive 4-year terms with partial terms lasting more than 2 years, counting as a 4-year term. Are there any questions of council with regard to 2019 R56 and 2019 R59?
Mr. Chairman?
Yes, Mr. Dyer.
Thank you. And again, thank you, Commission, for doing your work. There was a lot of it. I am curious as to why, having served in the House, I know that partial terms are not considered part of your full term. That's why people can serve 11, 12, or, more years down there because of that. And looking around at other states, I see that Michigan has similar language to what you're proposing. Colorado does, and a couple of other states. Did you look at what other states were doing or what other municipalities were doing? Because the ones that include that are considered among the most stringent and restrictive states in terms of term limits in the country, and I was wondering why we would want to be out of step with what the state legislative and statewide official term limits are.
Thank you, Mr. Dyer. Ted Mallow, 3379 Ashton Drive. We did look at that from a number of different points of view. In fact, we had, as I recall, 2 public meetings where it was discussed in public, considering everything from having any service as any part of a term counting as a full term to 3/4 to 1/2. In other words, we looked at all of those different options. And we did look at what some other municipalities had come down on the issue of term limits. And frankly, after lots of discussion on this, we ended up with what's before you.
Okay. I'm just curious
I
about.
can't tell you what cities we looked at off the top of my head. I know we looked at large cities like Columbus and Cleveland. We looked at small cities the size of Greene. But I can't enumerate for you off the top of my head.
I'm also curious as to what problem this is trying to fix. Has there been a problem with this in the past, or is this just
It wasn't
something someone
necessarily,
came up with?
it wasn't necessarily a problem. It was more of an omission in our charter. In anticipation that the issue could arise or would arise. And again, this was raised to the charter by a member of the public, which we thought was a issue that the charter ought to take under advisement. And so that's how we arrived at that as a recommendation.
Just, I'm concerned that it's out of step with what the statewide and legislators can do. So I just want to make sure before we do this that we're not running afoul of something. So I just want to be careful with that. That's all.
Are there any other questions of
Thank you.
council?
Mr. Chairman.
Mr. Humphrey.
One reason why we may want to think about this, especially in the context of Greene, I don't know how many times it has gone before the voters in terms of term limits for council and for mayor, but each time that issue has come before the voters in Greene, the voters have sided with the concept of term limits. One of the ways that you can get around those strict term limit interpretations is to have somebody get elected, serve only a portion of time, and get around those term limits. So instead of having a 4-year term, essentially serving many more years than that because you're stringing together those terms. So although I think it is a question, obviously states have taken it different ways and municipalities have taken it different ways. I think it is consistent with what the voters have said in Greene in terms of their favorability their view of term limits.
Any other questions or comments from council? Mr.
Chairman.
Spate, please.
Thank you, sir. First, I would like to thank the commission for all of your hard work. I know you guys dedicated countless hours to it, and it is much appreciated. As far as 2019 R56, I guess I really don't have a strong opinion on it one way or another, as well as R59, which is dealing with council. But the one thing I would recommend is that council consider pushing this to another election, only because we have 14 items that we're looking at. This one doesn't really seem to rate high on the chart as far as different items that we're going to be looking at on the ballot. I think it's something that we should clean up, but there's nothing saying that we can't push it to next year, put it on the ballot, leave the recommendation the same, and deal with it when we have a cleaner ballot to look at. Looking at everything that, the 14 amendments, as well as the positions that are up for election, I would hate to see some of the important things get clouded when a voter looks at term limits and immediately takes their attention away from something that may be more important for our current changes in the charter. So it's not that I'm for or against it or have any strong opinion one way or the other. I do feel that we should move this as well as some of the other items. And as we get to those, I'll make those known as well. But for this point, 2019 R56 and 59, I feel should be moved to next year. Thanks.
Any other council members wish to weigh in? Well, I attended all of the meetings, and my recollection of the discussion on this point was essentially trying to stay in step with the general consensus that term limits apply. And that if someone's appointed to a position and they spend more than 2 years in that position, doesn't that not fly in the face of the idea that an elected official should be limited to 2 consecutive terms? And I think that's where the discussion went, and the ultimate decision was, yes, it does, in light of the people who have spoken, as Mr. Humphrey has indicated, through ballot measures to say they wanted term limits. Having heard from council, are there any members of the public that wish to speak to R56 or R59? Okay, seeing none, we will move on to R57. Is a resolution to amend Section 3.2 of the Charter of the City of Greene to require that the mayor shall be a resident of the City of Greene for at least 2 continuous years immediately prior to the mayor's election or appointment, and declaring an emergency. And this is a provision that also has a companion, and that is 2019 R60, which is a resolution to amend Section 4.3 of the Charter of the City of Greene to require each council member be a resident of the City of Greene at least 2 continuous years immediately prior to each council member's election or appointment, and declaring an emergency. Are there any council members who wish to speak to 2019 R57 or 2019 R60?
Mr. Chairman.
Mr. Spate?
Thank you, sir. This one I do actually think is a good idea, but like the previous one, I do suggest maybe we push this to next year just to clean up the ballot. I think it's a good thing to have clarified. I was at that meeting when you guys discussed it, and I think it definitely, there's some good merit behind it. But one more thing, just to clean up the ballot, still keep it in the horizon, move it to next year. Thank you.
Mr. Dyer?
That's- In the interest of time, I will.
You take it back. Any other council members wish to speak to R57 or R60? Are there any members of the public that wish to speak to R57 or R60? Seeing none, we'll move on to R58. R58 is a resolution to amend Section 3.3D of the Charter of the City of Greene to authorize the mayor to make short-term interim or acting appointments of directors when necessary, and declaring an emergency. As Ms. Newbert had pointed out, this was a blind spot in our existing charter. It makes the effort to define an acting director as someone who is appointed on a temporary basis to perform duties when a director is on leave with the expectation of returning, versus an interim director who's appointed on a temporary basis when a director has left the job with no expectation of returning. So if a law director gets sick or if a law director resigns, there was nothing in our current charter that said what exactly the city should do. This clarifies that missing link, if you will. Are there any council members that wish to speak to 2019 R58? Hearing none, are there any members of the public that wish to speak to 2019 R58? Seeing none, we'll move on to 2019 R63 is a related provision. It is a resolution to amend section 6.2 of the Charter of the City Green to be consistent with section 3.3, which we just discussed, which requires persons appointed by the mayor as directors of city departments to be confirmed by a majority vote of the members of council. So this was a situation in which our current charter, 6.2 and 3.3, didn't have the same vote burden for confirming members of the charter. One section of our charter called for a majority. Another section of the charter called for 2/3. And the Charter Review Commission, after careful consideration, decided that a majority approval was appropriate. Are there any council members that wish to speak or have any questions about 2019 R63? Hearing none, are there any members of the public that wish to speak to 2019 R63? And seeing none, we'll proceed on to 2019 R61, which is a resolution to amend section 4.6 of the Charter of the City of Green to provide for council to fill vacancies that occur between a November general election and the end of December of that same year, and declaring an emergency. Any members of council wish to speak to this provision? Hearing none, are there any members of the public that wish to speak? Did I?
Yep, sorry,
Too quickly. Mr. Spate, please.
Thanks. Same thing as the other ones. If something needed to be pushed to another election to clean up the ballot, this could be one where hopefully it wouldn't apply in the next upcoming year or two. So if need be, push it to 2020. Thanks.
Any other members of council wish to speak to 2019 R61?
I would.
Mr. Shaughnessy.
Yes, thank you. I would just like to ask a clarifying question here. Now, typically, when a vacancy occurs, council then has 30 days to seek resumes, for lack of a better word, letters of interest from the public. By tolling this, are we actually just delaying getting another councilman in a seat, councilman or woman in a seat, because that particular body can't vote anyway until after January 1st? Would that be correct?
Mr. Chairman, I think I understand what you're saying, but I think that it's two different issues, because I think the current council who would not be voting on it could call for applications or letters of interest through the clerk. They just wouldn't be the council that would be voting on it.
Okay.
So I think it wouldn't delay necessarily having people begin to
In the
submit
process of
interest, getting the petitions
them in
or
the
whatever they
pipeline.
would do.
Okay, I just don't want to see it delay.
Mr. Chair.
Yes, Ms. Babbitt, please.
I just have a comment to what Mr. Spate said about holding some back for another
Please.
election. And I agree with him, and the first several that he mentioned, I think are good options for that. This particular one, I would like to see go on the ballot this time around, just because we could be facing this scenario after the upcoming election. And so I think if this is what our Charter Review Committee has put forward, we should get it into place before we might face it after this election.
Any other comments of council members? Are there any members of the public that wish to speak to 2019 R61? Any members of the, yes? Ms. Schweikert, welcome.
Stacy Schweikert, 1261 Steese Road. I'm by no means a municipal law expert, so forgive me talking out of turn here. But I just want to talk to you guys about this whole delay idea, because I understand, and given the volume of this, it sounds like a good idea, but I think it's contrary to our charter. Because I think our charter, section 9.2, says that the Charter Review Commission is going to bring everything forward for the next general election. So essentially, everything we're going to bring forward, it's now or it's in 5 years when we do our next charter review. Is that not right?
7.
Or 7, sorry, whenever the next charter review is. But I think it's like a now or never, unless I'm reading 9.2 wrong. Mr. Chris, am I wrong? Delay is not, I don't think, an option, so I think that kind of is an argument we're going down kind of a side path here that we can't go down.
Have
Mr.
we
Chris,
ever
could
done
you
in the
speak to
past?
that issue?
Don't believe that delay is really an option as set up by our charter. I'd have to look into that in greater detail. The other thing that you are looking at as well is if you do move any of these back, you're moving them to the 2020 election. And if you or anybody here is going to try to advertise or do anything, they're going to be just buried by the federal elections. So I don't know if that's always if kicking it down the road is the best thing for the people to get it before 'em. But I'll have to look into that in greater detail.
So,
I think we can take the timing issue under advisement. Mr. Chris can advise us as to whether that's even a possibility.
I believe if you vote it down, then you're going to have to bring it up on your own. You're not bringing it up as a charter review, so then you're going to have to go through your other protocol to bring this back. You can't say in 2020 we're going to accept charter reviews. I mean, that's not going to work.
So I think this issue of timing, we can determine whether that's even a legal possibility and proceed to go through the list to determine, ask our questions and get an understanding of what each charter member is about or amendment is about for purposes of this hearing.
Really, I think you guys are here to say, are you voting it up or are you voting it down?
Just for my clarifications, it would take 6 people not to move it forward. So if 2 of us were like, yeah, we're moving all these forward, it's a non-option anyway.
Exactly.
So it's a long shot.
Yes.
Okay.
so I guess, while we're on this topic, have we done it in the past to where we've pushed anything to another year after the last one? It's always been that year. It's all or nothing.
Can I
Okay,
say
well-
something? Council has the right to do a charter amendment at any time.
It does. It
So
does.
they could not delay necessarily, but they could bring these charter amendments forward.
But they have to
Anytime.
follow their rules to get to that point. It is not, you're not gonna say, well, we're gonna apply the
Table it
Charter
till-
Review Commission's, the 2019 Charter Review Commission, we're gonna apply that in 2020. No, you gotta go through your regular meetings, all your other stuff.
So procedurally, we would vote it down to avoid putting it on the ballot, and then next year, prior to the election, per all the stipulations of council rules and so forth, bring it back up as a charter amendment at that time.
You could do
we-
that, or you could
we-
not do it. But
We could even do it for the May election. We wouldn't have to wait till the general because it's not the thing. So if you wanted to
So
avoid
it's
the.
doable if we need to, but I understand what Mrs. Schweikert's saying. Not just tabling it, actually voting it down and bringing it back up, which is good clarification.
Mr.
to have.
Humphrey, please.
Yeah, and as Mr. Young said, I think it's highly unlikely that 6 of us would say that we put off the work that was done by the Charter Commission and not put it in front of the voters. I mean, is it a lot that they're going to have to vote on? Yes, it's a very unique circumstance because of the way this was all brought out and the number of deficiencies that had to be corrected. However, I think that as we're focusing on the charter, first of all, I trust the voters in the city of Greene to be able to inform themselves on the issues. And I think that once they are communicated on what the issues are, they're going to be able to go through and to vote on those. Will everybody vote on every single one? Probably not. But even currently, you have an undervote with a short ballot. So those who are inclined not to cast their vote on that are in one sense casting a vote on it because they're not taking a position and they're letting their fellow citizens make the decision. But I think that it would be a mistake not to offer this to them while we're talking about the charter. Our charter does talk about doing this every 7 years. And if we start to get in a habit of parsing things off because we're concerned that the voters can't take it or can't get through it, I think that would be a mistake, because then we're always going to be pushing things down the road. If there are other things that didn't make this charter amendment process, then at any time, the council could, by its own vote, determine to put something into the charter, and then that would become part of the normal process.
Councilman Jurgen?
Yes.
It also says that council shall submit the amendments to the electors at the next regular municipal or Ohio general election. So I don't believe May is an option either.
Okay. Any other comments of council? Any comments of members of the public with regard to 2019 R61? Welcome, Ms. Small.
Thank you. Linda Small, 3819 Greenfield Road. This is just a general observation. The very first sentence of the resolution, all the resolutions say, the charter is required to be reviewed every 7 years. And I know there was discussion in the committees. Maybe that's too long. Maybe that period of time should be reduced. I think it should be considered at some point, because if you look at the quality of what the Charter Commission did this time and some of the intricacies of the changes, it's very evident that the city has changed over this period of time. We've matured. The JEDs didn't exist when the first the first Charter Commission was pulled in, and there's very good reason to think maybe something else will come forward that didn't exist when this happened. 7 years is a long time. It puts a tremendous strain on the Charter Commission to go back and try to figure out what was in the mind of the Charter Commission yesterday, much less 7 years ago. Ted was on the first charter change. Well, you made it, didn't you? Yeah, he was part of the original committee that put this together to make us a city. And we are fortunate that he's still around, and he wanted to change it again. But he could probably attest the same way I just observed. Things have changed. Lots of things have changed that have to be addressed through the charter. So I don't know where it would come in. I don't know if it would be a charter recommendation. Maybe I do know that. It would be a charter change, so we would have to go through the same procedures to make it a longer period of time. But I think we should all think about that. Some of us aren't going to be around in another 7 years. So you are a living, working body. The city is a living, working body and must change to what's happening. Just a suggestion. And I also want to thank the Charter Commission. It's a thankless job. And they did a wonderful job, and they put it forward as if it was a paid job that they had to do, and it wasn't paid at all. I don't even think they got hamburgers. So thank you very much.
Any members of the Charter Review have any response? Any other members of the public wish to speak to 2019 R61? Then we'll move on to 2019 R62 as we turn towards the provisions that focus more on the elected law director. 2019 R62 is a resolution to amend Section 5.4 of the Charter of the City of Greene to set requirements for nominating petitions for the office of the Director of Law and declaring an emergency. Are there any members of council that have questions or comments with regard to 2019 R62?
Yes, Mr. Chairman.
Yes, Mr. Shaughnessy.
Yes, I'll read the ballot language that voters will see, and then I'll ask my question. So this one, the ballot language says, shall Section 5.4 of the Charter of the City of Greene be amended to require a nomination petition for the office of Director of Law to contain not less than 75 nor more than 225 signatures of registered electors of the City of Greene. Then they can vote for the amendment or against the amendment. So my question is, if the voters reject this amendment, what will be the signature requirement for the Director of Law?
For the courts to determine.
That's a legal question, I suppose, Mr. Chris, but the issue 14 attempted to address this issue by referring to, pull it up here a minute.
Yeah,
Yeah.
By referring to 5.4, it says, this is from the initiative petition, "The law director shall be nominated pursuant to 5.3 of the charter in the same manner as the mayor, requiring the same number of signatures as councilmen at large." R62 simply puts that requirement in the right part of the charter, makes issue 14 consistent with the rest of the charter. So in essence, I view this more of a housekeeping provision to make issue 14 consistent with the current charter. So I think we would be interpreting the language that's issue 14, but this is an improvement on it because it puts that provision in the right place in the charter to make it consistent.
Mr. Chairman?
Yes, Mr. Humphrey?
It seems to me that it would probably be, if the voters voted against this, you'd have to have some requirement. I think the lowest level of gaining signatures for an election to get your name on the ballot is for a ward council person, and I think that's 50 and not more than, I'm not sure what the top number is. Is it 150?
150.
So 50 to 150. So, I mean, it seems to me with statutory interpretation principles, you'd go to the lowest requirement that is applicable in your charter to at least have something, but you'd probably ultimately have to define it.
That's one interpretation. This, and I suppose the point of this provision is to not worry about legal interpretations of our charter, but to be clear so that we don't have to guess and we don't have to, engage in legal maneuvering to understand what our charter says. So,
Well, I know it's a question that would probably require digging through the whole charter again to find the answer. So in the meantime, I'll work towards trying to find an answer. Maybe it's in there already, I don't know.
it's
But
in section 5.4, but the problem is it's subject to interpretation under the current charter. Anyone else on council wish to comment or ask questions about 2019 R62? Any member of the public wish to comment or ask any question about 2019 R62? Okay, then we'll move on to 2019 R63. We already did. Moving on to 2019 R64, a resolution to amend section 6.4A and 6.4C of the Charter of the City of Greene to establish the current requirements of qualifications for the position of law director and declaring an emergency. Ms. Dufferin did a nice job of walking us through this, but I'm sure there's questions or comments of council, so let me open it up to council members. Mr. Dyer.
Mr. Jurgen, just a technical matter. This is the only resolution that includes two sections to be altered. Is that a problem with the single subject rule? Is there a single subject rule on these things, or are, each of these are dealing with single sections, and this resolution deals with two, which puts a lot behind the ballot language, which is certainly not reflective of everything that's in the proposed amendment.
Mr. Chris, can you speak to that, please?
I've really tried to stay out of matters dealing with the law director in all of this, since I have a situation where a current partner and a former partner are running for the position. But in response to the question, I believe that in the charter amendment, this resolution, that we can have both of them together in that, since it deals with this this section. It probably could be separated as well, but I don't believe we have a problem with it established the way it is.
Did our outside counsel, Mr. Hanna, weigh in on the wording and division and the way we have set forth?
I stayed out of those discussions dealing with this. I don't know if Mr. Mallow or Mr. Mager or anybody can help me out there, because I did not participate in these.
Again, Ted Mallow, 3379 Ashton Drive. I think to Mr. Dyer's point, there are probably 5 different ballot issues that could be brought under 6.4A and at least 4 under 6.4C to address the single ballot issue. if it was necessary to go that way. It's very possible that you could have a single ballot issue, I think, that would probably be almost a page long, that would encompass all of the different things that are included in the resolution and is recommended by the Charter Review Commission. And frankly, I think it would be prudent to keep, not to put Bill in a conflict situation and to really have this issue addressed by your outside counsel as to whether the single ballot issues are the best way to go, or a textual approach with all of this together in one resolution is viable. And I say viable because the Secretary of State, the Supreme Court of Ohio, have guidelines for ballot issues that require certain levels of clarity and transparency. The single ballot issue is just one of those. In fact, a recent Supreme Court case struck down a ballot issue that included the entire recommendation of the initiative because it would confuse the voters. So I think having an outside counsel at this stage in the game look at that issue as to how to address the ballot language and advise council appropriately.
Then to go to Mr. Dyer's point, I think we should be sure that this issue is submitted to Mr. Hanna for feedback so that we're not creating a legal issue with the way that 2019 R63 is structured.
I just also have a couple of follow-up questions. There was a lot of concern. We heard from a lot of people coming up, including several people in the front row here, talking about the concerns about issue 14. And one of those concerns is that would it be too restrictive. The old language was too restrictive, saying it was 5 years of muni law experience was too restrictive. No one would file. 6 people filed. And this new language would seem to be even more restrictive. I'm just wondering how you're able to square that circle. The old legal, the muni law language, which my understanding was the Supreme Court ruled that like in the 80s. So this has been around since before we set up the charter in the beginning. So we've had this 5-year of muni law experience issue since the beginning of our city's founding. It seems that we're making this far more restrictive so that far fewer people would qualify for the ballot. And I'm just wondering where that language came from and what other municipality requires a law director to have this kind of experience, if there are any.
Sure.
Mr. Mager.
CJ Megger, 3794 Ramsey Drive. And Mr. Dyer brings up a good point. What we try to do as part of the commission is implement issue 14 the best we could. What issue 14 did not do is remove the municipal law requirement under the charter. So we had to look at this thing as 2 options, and this was part of a debate for at least 3 meetings where we opened up the public discussion. What we decided was we can go one of 2 ways. We can either remove the municipal law requirement, which issue 14 did not take that out, or we could just comply with existing law and as define what a municipal law is. We decided to go with the latter approach because we believed the voters didn't have a chance to vote on it to remove municipal law as being a qualification for law director. Where we got the language from was the same court that ruled that if you don't define it, you can't use it to enforce or restrict the run of a law director, cited the Black's Law Dictionary definition of what municipal law means. So what we did is we pulled that definition as a starting point, in the court, Supreme Court has since cited to that definition as a definition for municipal law. So as that starting point, we used that and we expanded upon it, we believe, to make it more encompassing as instead of less restrictive. And then some of that language includes, I think part 2, I don't have it in front of me, that's substantially equivalent, which would encompass prosecutors who do civil matters. So we took the more restrictive definition that's been used and made it broader. I know it, to some people, it might not read that way, but that is the more broader definition as opposed to the more restrictive one, which is Black's Law Dictionary. And we just go back to trying to implement what issue 14 did and what issue 14 did not do, and that's remove the municipal law experience.
Because, we were told that, my understanding of the spirit of issue 14 is people voted to have people with the same level of experience as the appointed law directors have had, 5 years of muni law. They just got to live here so that if they make a decision, they got to live with that decision as well as the residents. I mean, that was my understanding of what that whole qualification was. throwing in 2 paragraphs of Black's Law Dictionary definition of this when, you know, people are going to be going to the ballot box saying, I've got this experience, and someone else is going to say, I've got this experience, and the people make that choice. I mean, I think that's, you know, I think that was the spirit of issue 14. And, you know, when you look at some, you know, the only requirement to be the Ohio Attorney General is to be an elector. You don't even have to be a lawyer.
Sure.
But do you think a non-lawyer has a chance against a lawyer? No.
Well,
So again, I think it's, you know, again, there was a lot of concern that issue 14 would keep people off the ballot. I think that concern is heightened with this additional, you know, coat of arms that people have got to have in order to become our law director. You know, I am sure that there are people on the U.S. Supreme Court that wouldn't qualify under this definition. So I'm just I'm concerned about including that. I mean, I just think that it's the 5 years of muni law experience has served this city well since its founding. I don't see why it wouldn't continue to do so in the future.
Sure, just a couple quick points. I don't agree with the characterization that we just took Black's Law Dictionary and threw it in. I said that was our starting point, and we revised that language from there. So we didn't just take a definition and plug it in there. Second, the issue 14 did not weigh in on the qualifications law director. It just added 2 more, which is being elected resident of Green. So with the intent of what issue 14 was passed, we just try to carry it over. And when you cannot enforce a municipal law definition, municipal law requirement without putting a definition in. So we had to create a definition because issue 14 did not take it off. Those are my only points. Thank you.
Mr. Chairman,
Yes, Mr. Humphrey.
you know, when we talk about the spirit of issue 14, I don't think that we can talk about it in a vacuum. We have to talk about the ballot language that people actually voted on. If the ballot language that had gone to the people to vote on had removed the requirement in the charter that you have to have 5 years of municipal law experience, and then the Charter Commission would come along and say, well, we don't think that's a good idea, then people would say, well, you can't do that because this is what the voters voted on. But when the Charter Commission says, okay, we're going to take the ballot language as it was voted on by the voters, and we're not going to change it. In fact, we're going to make sure that that ballot language is enforceable, because if I understand what Mr. Meager is saying, if we don't define it, then the Ohio Supreme Court says you cannot enforce it. So by us not defining it, we would be telling the voters, we don't care that you didn't want to remove that. By not defining it, we're removing it indirectly. And then I think that we could legitimately be criticized by the voters because that's not what the voters voted on. That's number one. And number two, I'm sure there are people on the Supreme Court that are not qualified to practice in every area of law, just like I'm absolutely certain that my family practice doctor could not do my heart surgery. So the practice of law is a specific practice. The practice of government law is a specific practice. We should think highly enough about our city and about our voters to say, we want someone qualified to do the job. And if we can't find somebody qualified to do the job within Green, I, for one, want somebody to do the job who actually has the qualifications to do it. And that's what the voters voted on, and I think that's what the commission has upheld, and certainly that's what I'm in favor of.
Other members of council, Mr. Shaughnessy.
Yes, Mr. Chairman. I do have a question concerning the substantially equivalent position requirement. It's my understanding that that relates to the experience as a director of law or assistant director of law. So my understanding is that you have to be a director of law or an assistant director of law or have the substantially equivalent experience of a director of law or assistant director of law. Is that correct?
Vivian Dufferin again, 2821 Crow's Nest. Yes, our intention is that you would have to be a law director, an assistant director of law, or you could work in another capacity fulfilling those same duties that a director of law or assistant director would have. in representing municipalities. So you could work for a law firm, for example. You could have a private practice that represents cities, townships, villages, counties, or offices within those, and that would qualify, even though your title may not be law director or assistant law director.
So does this narrow the field compared to what we have now?
No. It's an either-or situation. So they have to be experienced as a director of law or an assistant director of law or the equivalent position representing a state or a political subdivision. So, or they can have substantially equivalent experience, say in a private practice or in a law firm representing those same entities. So if I am in a law firm in downtown Akron and I have the city of Akron as a client that I'm representing in union negotiations and charter drafting or whatnot, that would qualify as substantially equivalent experience to that of a law director.
So are you saying this doesn't change at all the number of qualified candidates that exist in Greene right now? The number of people who sought the job, the law director position, they would all be qualified?
Oh, that's a different question. No, I did not say that.
Okay, so there it is.
The
less
language
under
as
this
it's
definition.
worded now is not enforceable according to the Ohio Supreme Court. So probably everyone that has pulled petitions to be on the ballot would meet the requirements, which essentially are simply to be a lawyer and live in Greene.
Do you know of any other cities in Ohio with this type of restrictive qualifications?
Which other municipalities that have defined this way, I do not know if others have, but if they do have the requirement of municipal law experience, it does need to be defined. So I would assume that other municipalities have defined it in some fashion. And we felt this was the most specific definition that we could come up with while still leaving it open for as many candidates as possible that had the relevant experience.
I just have one more question. Was there any study done looking into how this definition would affect the number of qualified candidates in Greene?
Study done?
Yeah, any research or I don't know your whole process. I know you consult with an outside attorney that the city hired. I don't know if he had any input with regard to that. If it
No,
would
our intention really was to
increase or
take the
decrease.
existing language and to just not change the requirement, but just to further define it. And this was the intention of our charter language since we have had this language in there about the 5 years muni experience. If we didn't intend to have that, we would just simply say, you have to be a lawyer in good standing.
Thank you.
Mr. Maker, please.
Yes, CJ Megger, 3794 Ramsey Drive. Mr. Shaughnessy, just a follow-up to your question. We had two options basically as a commission, either vote to remove the municipal law requirement since it's not really enforceable how it's written, or define it. And this was a part of a long debate between us. And we felt like the language of issue 14, both on the ballot, like Mr. Humphrey pointed out, but also the actual language of the initiative, did nothing to remove that qualification from the charter. So we felt like we had one or two options. I don't want to put my name on a charter that has a provision that's not enforceable because it's not defined. So what we had to decide was either remove it or we define it, and we decided to go with the definition route. Thank you.
Mr. Chairman?
Yes, sir. Mr. Dyer.
But again, the Supreme Court ruled that in the 1980s. So this has been true of our charter. So the 5-year municipal law experience has been unenforceable since 1992?
Ted Mallow, 3379 Ashton Drive. That's a good question. And reasonable minds can differ, and attorneys can have different opinions on this. This wasn't really an issue when the mayor was appointing the law director pursuant to the qualifications required in the Green Charter, also subject to approval of council. So it was really the mayor and council that was attaching the definition to what those qualifications meant. Had there been a challenge, it would have been up to the mayor and council to defend those qualifications and what they meant and how they were interpreting it. But again, this wasn't an issue and didn't become an issue until we had an elected law director. Once you have an elected law director, somebody's got to define the qualifications if you're going to have them,
Why?
because who's going to enforce them?
The voters?
If you have no qualifications,
You don't get elected. I mean,
well, we might have that this time.
I mean,
The,
Again,
the argument that we had 6 people submit petitions to be elected must mean that we have a plethora of qualified attorneys in Greene as a result of issue 14. I think that has yet to be seen. But the qualifications that the commission defined and recommended to be put on the ballot were intended not to limit, but to expand the number of qualified applicants that can apply for the position. Maybe one of the unintended outcomes of this is we'll get a number of qualified attorneys moving into Greene. Thank you.
Thank you. Any other member of council wish to speak to 2019 R64? Mr. Spade.
Thank you, Mr. Chairman. I understand the reasoning behind adding this job description in there, based on everything you said. However, a red flag comes up to me, and that is when the mayor is allowed to appoint an attorney to fill this position, they're not required to pick an elector of the city. To me, that throws up a red flag. So if our pool of candidates are that small, or could potentially be narrowed down based on this qualification that is expanded upon in this charter change, then why would the mayor need to go outside to fill an appointment? So to me, that was a red flag. And that's one thing that is a concern of mine, because I do feel that this sincerely restricts the pool of candidates and would not enable the true will of the voters when they passed issue 14 to be enacted by having an elected law director. So that's a concern of mine. But what's a bigger concern of mine is that that red flag is going to echo with other voters in this community. And come election time, when they're looking at this on the ballot, and we know a PAC's going to form for it, a PAC's going to form against it, and there's going to be some arguments. And if this fails, this particular amendment fails, we're left with a charter that's in shambles when it comes to our director of law, which we now have just elected. So I guess just in a big picture scenario, what I think would be a good idea is to send this back to the commission, ask you to remove that section, bring it back, let the community vote on it, and I'm pretty confident the community would overwhelmingly pass this charter amendment without that job description in there, and then reattack in another format. If we're that particular on defining the job, let's do it at another time. But right now, if this doesn't pass, it could be detrimental to the director of law that we just are going to have elected in January. Like I said, I understand the reason behind defining the job. It makes sense. I just don't know if lumping it in this giant charter change that we need to pass is the right thing to do at this time. And we've been operating with this charter since 1992 with that definition in there. A couple more years aren't going to hurt us if we have to reattack with a council-initiated charter change on a ballot that defines the job at that time. Thanks.
Mr. Chairman,
Mr. Humphrey.
you know, I really don't understand the argument against. I mean, the argument against essentially is whoever decides to run, whether they're qualified or not, the voters will get to choose. So let's think of a scenario where we have no one who's qualified in municipal law, where at any given time that could happen. Do we really want, as a city, to have our city represented by somebody who does not know what they're doing when it comes to the specialty of municipal law? I mean, it's a specialty for a reason, and people devote their lives to the study of municipal law. We've been advised by somebody through the Charter Commission on that very thing. So I don't understand the argument, well, let's just accept whoever we get regardless of whether or not they're qualified. We're paying whoever the director of law is going to be a lot of money for part-time work. I want them as a taxpayer, let alone somebody serving on council, I want them to know what they're doing, because if they don't know what they're doing, what we're going to have to do as a city, we're going to have to go out and hire competent counsel to be able to represent us on those issues because they're just learning on the job and they don't know what they're doing. So I think all this does is say, we've had it in our charter all along. The Supreme Court says, here's what you do to make it enforceable. We broaden the definition so we don't just limit it to 5 years of municipal law experience, which the Charter Commission could have done. They broaden it out to include other government law experience so that you expand your pool. Otherwise, you don't define it, it's not enforceable, and you are at a higher risk of getting somebody who's not qualified to do the job.
Mr. Chairman.
Please.
I would just like to say, I think that a narrow net was cast, not a wide net. This is about the definition of what is municipal law. And it could be defined wider so that we can include more potential candidates. I do want to point out that in Ohio, government law, or municipal law, is not a specialty. It's not a specialty designation. The law has 18 specialty designations. That's not one of them. So I would just like to say, if it was, what this has done is it's defined it in a narrow way, and I think that is what's limiting here, and that's what's going to hurt the voters' ability to have qualified candidates.
Mr. Chairman?
Mr. Dyer?
Yeah, I guess I just trust people to, choose qualified candidates. I mean, again, I'm not, will it be perfect every time? No. But, even though we've had, appointed law directors, we have had very large outside counsel charges. When 2015, we were around $100,000 for outside counsel. Now we're over $200,000 for outside counsel. We employ outside counsel all the time, even though we have appointed law directors. So I'm not convinced that we might have to go to outside counsel for some sort of specialty or something is going to be a detriment to this. I just think if you have two people who put up their qualifications and the residents of Greene have an opportunity to vote for them, they're going to pick the right person. I just trust them to do it. I don't know. Maybe I'm just naive or, whatever. But I just think that, if you have, the whole campaign will be about qualifications. And, the qualifications, the strongest qualifications will probably win this thing. And I'm just amazed, just as a general comment, I'm just amazed at the minutia we're getting into on the law director. You go to Talmadge, and Talmadge, has had an elected law director for years, and they've got, they had Bob McGuire there for years. I don't think anyone would say that Bob McGuire doesn't know what he's doing. Lisa Miller over in Barberton has been there for years. I don't think anyone would disagree that she knows what she's doing. We have an elected law director of the state of Ohio who doesn't even have to be a lawyer, by the way. I don't think anyone would think that we've had horrible attorneys general. We have an elected law director to run the county. We have elected law directors all over the place, and I just issue 14 was an open wound, and I just think getting back into this without, when clearly people were voting to have the same qualifications we've always had since 1992 and let the people decide, let's make sure they're elected and they live here. I just don't know. I just don't know why we keep trying to pick at this open wound. I wish it would have just been, what was in issue 14, maybe cleaned up a little bit. But we don't need this. I would completely agree with Mr. Spate that we do not need this right now. And that's all I'd say.
Before I open the discussion up to members of the public, Ms. Babbitt or Mr. What is your name? Young.
Young.
Do you have anything you wish to add to this?
I think qualifications matter. I don't think it's unreasonable to require qualifications. I mean, we had a panel of directors over there. They just didn't accidentally get those jobs. They're qualified to do those jobs. We entrust them with a lot of important things in the city of Greene. I mean, unless you're me sitting here on Greene City Council, qualifications matter.
Ms. Babbitt?
I think we should really think about everything that's been said tonight. I think we keep coming back to the same point. We don't realize we're making the same point, and that is the electors went to the ballot and they passed issue 14, so they want this. We have citizens and electors of Greene working on our charter review commission, and yeah, getting into minutia because they felt that was the best way to thoroughly make a charter that would pass muster. And they worked hard, and they're residents with qualifications to do it. I respect and trust them. And now we'll take it to the voters, which we're all talking about. We want to take things to the voters, and we're going to trust them. So let's trust them to evaluate what the charter review commissions put together for us. I mean, the process is working. I think it doesn't sound like it, with everyone arguing about it, but in reality, I think that's exactly what's happening. The voters got their wish with 14 being passed, and we're going to elect our law director. The people that we put our trust in have fine-tuned it in a way that they've worked hard to try to make it work for our city. Now we're going to put that back to the voters and give them a chance. And the whole process is working the way it's supposed to. I think we just need to refocus on that.
Thank you. Mr. Shaughnessy, briefly,
Mr.
please.
Chairman, yes, briefly. I just want to say I agree with Mr. President Young. Qualifications do matter. I would just like to point out, though, that a majority of the Supreme Court of the United States would not qualify under this definition. Sonia Sotomayor, Ruth Bader Ginsburg, Stephen Breyer, Neil Gorsuch, Clarence Thomas, all, if they were licensed in Ohio and a resident of Greene, would fail to qualify.
But here's the thing, I may
Law
qualify
director.
under, having been a civil prosecutor, I probably possess these qualifications, but I don't possess the qualifications to be a Supreme Court justice. I think the point is, that's apples and oranges with the Supreme
I
Court.
think Supreme Court justice qualifications are just to be an attorney in good standing. Is that correct, Steve? Mr. Dyer?
I believe so.
Well, we are saying the same thing, but since the point was made, if you look at each of those people, I think that you stated, Mr. Shaughnessy, they
Yes.
would qualify if they were licensed in the state of Ohio because each of them had government law experience before they sat on the bench. But I take your
Not
point.
substantially equivalent to a law director or assistant law director.
But they had, well, a lot of them were prosecutors.
That's what we're arguing
so-
here, is that narrow definition. And that, we all want qualifications, but that narrow definition is the sticking point.
Okay, let's wrap up discussion on this so we can move on. The only thing I would add is a little dovetail on Ms. Babbitt's comment, and that is, at issue 14, the voters were not asked whether they want to maintain qualifications for the law director. That question has not been posed to the public. And while I concede that Mr. Dyer makes some good points, I disagree that we should take that question away from the public, because they deserve to answer and get a choice as to whether their law director should have 5 years of municipal experience or not, just as Mr. Dyer had eloquently argued they should have a choice as to whether or not their law director should be elected. So let's not take the choice away from the people. They haven't spoken to this issue. It hasn't been presented to them. My view of it is, let's let the people decide. If there's anyone here who would like to speak to that issue, please come up. We're talking about 2019 R64, and this is your chance.
Pat Karleski, 3878 Greenfield Road. This whole process, the charter review and everything, is new to me, and I'm not very knowledgeable. I tend to be a little bit more down to earth. When we have a job that is going to pay, what is it, $55,000 on a part-time basis, and you don't have any qualifications? Okay, let's suppose that my buddy, Mr. Pickett, now he's a fine engineer and we agree on so many things. But he decides, something happens, and all of a sudden, you know, the city engineer has to be an elected position now, okay? So, hey, engineer, any kind of an engineer. You don't have to have experience in building roads and bridges and planning and all this other stuff. So let's go out and hire a nice retired lady who has experience in aerospace and aeronautical engineering, and let's get her elected to be the city engineer. And you know what's going to happen to our city engineering programs? Folks, think of it, common sense. Would you hire a plumber to do the wiring in your house? No. Okay, I mean, I could hardly sit still in my seat back there. You have to have qualifications. Plus, they provide for equivalent experience that can be evaluated in place of actual director or law director experience. I did that with technical people that I hired when I was working. We had people who came in who didn't necessarily have an engineering degree. But when you looked at their experience, their qualifications, their education, you could grant them equivalencies and you could get them certified as engineers, and they would fully meet the qualifications of the job. You have to have qualifications. You are wasting my $55,000 if you don't have qualifications. I see nothing wrong with these qualifications, as stated. Thank you.
Thank you. Would any other member of the public wish to speak to 2019 R64? Welcome, Ms. Stoynoff.
Hello, Katie Stoynoff, 235 Lakefront Drive. I guess I'll start with a little disclaimer, which you'll probably have to hear multiple times when I come up here. I'm an elected member of the Green School Board, but I'm not here tonight representing the Green School Board. I'm here as a citizen and an elector. I think the problem is not qualifications. I think we all agree that we want qualifications. The problem is the narrowness of the qualifications are here. The electors did not ask us to, or ask you to narrow the group of people who would be eligible, and this does do that. My bigger concern is the ballot language, which I know has been revised, and Mr. Shaughnessy let me take a quick look at it. So I'm not able to quote up from it because I just looked at it. But the problem is that these qualifications, yes, thank you, whoever's Molly or whoever's operating that,
Nicole.
thank you. If you take a look there towards the middle, it adds almost everything that is talked about in here, except when it talks about qualifications, I think it makes reference, and I'm sorry, I'm not seeing it right now, as fully defined. 5 years of employment, public practice experience in municipal and other governmental laws as more fully defined. I think, to be upfront, especially because the arguments of those that were against issue 14 was that the ballot language was misleading, that for this to be true non-misleading ballot language, that definition that we all just looked at needs to be included in the ballot language, because it doesn't say there how we are further defining this municipal law. And so I think if that ballot language isn't altered to include that, then this is also misleading ballot language, because they are not seeing right up front what those qualifications will be. So that's my concern. I guess I'm also concerned that the qualifications could possibly lead us to a position where we do not have any qualified candidates. So even if there is a vacancy or something like that would happen, if council goes to approve there's no qualified candidates, then who are they going to appoint? Then it's going to fall to the mayor to then appoint somebody who could be an interim and be from the outside. So I think the narrowing of the pool creates a possibility that we're going to be right back to what we had, which was an appointed law director, which is also a concern that I have. Thank you.
Mr. Malo, please.
Ted Mallow, 3379 Ashton Drive. I totally agree with the first point that the previous speaker made. And that's essentially what I was trying to address to Mr. Dyer about the ballot language for this section, that could actually be broken down into about 9 different ballot issues, so that it would be fully transparent and all of the language would be included on the ballot for the entire text that was recommended by the Charter Commission. And I think that's what needs to be reviewed by outside counsel, and to advise the council on how to address that issue. But I completely agree with the point that the previous speaker made.
Thank you. I'm sorry. We'll come back to you, Mr. Mager. I've promised this podium to this next resident.
Greer Cab Langcamp, 465 Comet Lane. In reading this, the concern that I have is the paragraph, it says, for the purpose of the section 64A 3C, it goes on and says, shall mean experience as a director, assistant director, yada, yada, yada. But what it says is it's all on the government side. There are every problem has 2 sides. There's a plaintiff side and there's a defense side. This totally wipes out anybody who has ever been a plaintiff's lawyer against a municipality. And I think that that's wrong. I think that we really need to have, this needs to be open for either part, because you know and I know lawyers switch sides all the time. They may begin as a plaintiff's lawyer and then go to the defense side, or they may be on the defense side and switch to the plaintiff's side. I think that you've got this written now that it says, well, it's only if you work for a municipality or the feds or whatever. There are a hell of a lot of good lawyers out there that know both sides of the law because they have to defend their clients against what's going on. And so I think that really needs to be considered with this law, this section of the law. Thank you.
Thank you. Ma'am, did you wish to be next?
Name's Deb Carney, 988 East Turkeyfoot Lake Road. I'm kind of a little bit confused with the law director thing. 6.4. I'm not sure of the gentleman on the end down there. His question was, he hoped that the people were smart enough to, with the issue of the law directors, to vote properly on this, yet in 6.4, our new wordage takes the people out of this whole section and just leaves that the law director shall represent just the city. When you start removing verbiage like that, it kind of takes the people out that were not smart enough to make the choices there. And when I sit and I listen to all the questions and everything about this, we, the residents, are smart enough to make that choice. You know, let us make that choice on the law directors. Let us have that vote. And that's mainly, and from all that I've heard of the other questions, give us that choice. What has worked in the past has worked. The 5 years that the law directors have had in training has worked. So, and yes, having education, 2 more years or whatever of experience, yeah, maybe it would help. But for whose side, the city or the people? I guess. That's all I have to say.
Thank you. I will come back to Mr. Mager.
Jane Weaver, 4013 April Drive. And as I read this, I think it broadens the definition of what we had before. Before, it was just the 5 years. And now we're going, or substantially equivalent experience. So that broadens the the number of people that we can have. And we can't leave it as it was because the Supreme Court says you can't do it, it's illegal, you have to define it. So how can we not define it and go against what the Supreme Court is telling us? I mean, it's just wrong. You can't do that. If you know that you need to do it, to define it, and you don't, then you're like breaking the law. You got to define it. And the issue of why it's narrowing is because they have to be a resident of Green. I mean, that's what is narrowing the field, not the experience that you need, because it's work to have 5 years, but because we need to define it, you broadened it, and hopefully we'll get some good people. Thank you.
Thank you.
Mr. Chairman, sir, may I make a statement real quick?
Yes.
Okay. I'm just going to ask members of council, I won't bring this out on the public, but out of members of council, there are 5 attorneys up here. Out of the 5 attorneys up here, who would be eligible per this definition to fill this position?
Mrs. Babbitt, and it's a good
Well,
thing.
I'm close.
Close. So out of the 5 members of council up here who are attorneys, who feels they are capable or competent enough to fulfill this position if elected? Who feels they could learn it to the ability to learn what is needed to be a law director for the city of Green? Out of the 5 attorneys up here, do people feel that, or do you feel that you could do this job if elected to do so?
Absolutely.
Mr. Spade, I don't know of any other entity. I mean, I wouldn't go to my doctor and say, I know you've never done this surgery before, but could you learn it?
We're
I
not doing
wouldn't-
surgery.
well, wait a second,
We're
though.
practicing law, Mr.
That's
Humphrey.
right.
This is a big difference. We're not removing hearts and organs. We're simply practicing law.
No,
There's
but you
books
could-
and
I've s-
Writing ordinances,
guidelines to
Chris,
help you
come
with
on.
this.
I've seen bad lawyers or lawyers who did not know what they were doing cause millions of dollars of problems for clients because they did not know what they were doing. So I think we're getting back to kind of where we started. It is either an argument that we don't care if we have someone qualified as long as we have someone,
It's
Or
not
we-
black and white, Chris.
or we get someone who's qualified. Now, I have no problem if we have 3 qualified people and then they go to because they meet the baseline definition, and they go to the voters and say, I'm more qualified than the other 2, and here's why. That's the kind of argument you do want to hear as a voter, because you want to make sure that the people who are representing the interests of the city, this is an important job. It is a very responsible job.
I guarantee you could do it. If you were elected in that position, I have all the confidence with 8 years of being on city council, I have all the confidence in the world that you could perform that job. Your experience as an attorney, I don't want the members of council up here to downplay your roles in this community. I know you guys could do it. So my point is that by restricting this as much as this legislation does, where we found out that potentially 1 member of the 5 attorneys up here are eligible to do this job, I know you all could if elected to do so. So that's why I go back to the point where I don't know that it's needed right now. And just for the argument's sake that we've been up here talking about this for so long, it's probably better to take it out so we can fix the charter as originally proposed.
We keep saying that we're restricting, and I guess if you repeat something often enough, that narrative takes root, but we're not restricting anything. What we have had in the past is 5 years of municipal law experience. That definition under this charter amendment is actually broadened. So as opposed to being restrictive, what we have had is qualifications. More people qualify. So we can keep saying over and over again that we're making it more restrictive when actually we're making it broader, but it doesn't make it true. This is a broader definition than we have ever had in the city of Green. It will bring in many more people, but it will also ensure that the people who are brought in are qualified. That's just the fact.
I want to make sure no one else wants to speak to the issue. I guess to quickly answer Mr. Spade's question, if I were called upon to be law director, I certainly would put my heart and soul into the job, just like I do councilman. But part of my motivation would be fear. I would say that the question is not whether or not I feel like I could learn the issue of law director. The question is whether it's better to have someone with 5 years of experience versus someone who's eager but has none. And I think that's a question that our electorate is entitled to answer. So I think, in my view, the question is really on them. Anyone else want to speak to the issue? Ms. Stoynoff, we'll give you another chance.
Katie Stoynoff, 235 Lakefront Drive. So the question that I meant to ask when I was up here before is, who will enforce and determine if someone meets those qualifications? So what if someone pulls their petition, they file those petitions with the Board of Elections? So where is the enforcement of these qualifications come from?
Mr. Mager? Thank you.
That was going to be my point that I wanted to come up and talk, how would this play out? I think by putting a definition in there, what you do is you have protests between candidates. Without having a definition in the charter, you can't have two candidates challenging each other saying, hey, we need to have a protest because this person doesn't meet the qualifications. So that's why we had to put it in there, to give that the people who would protest the ability to do so based on a definition in the charter.
But that didn't exactly answer my question. Are we going to court? Like, what happens if someone says this person does not meet this qualification and cannot be on the ballot? Who's going to say that?
Sure, so it'd be between the candidates. So if one candidate feels the other candidate is not qualified based on definition, they would charge the qualifications. Now, could it ultimately end up in court? Yes, it could.
So the Board of Elections would then become involved and have a hearing.
Mr. Malo, thank you.
Ted Mallow, 3379 Ashton Drive. The short answer to that is that it would end up in court, and that a judge would look at the qualifications against what the charter says. For example, some of the more recent cases, the Supreme Court has looked at the qualifications of a candidate that had X number of years of experience, but in certain kinds of legal work, and determined whether or not that legal work qualified as experience under the charter provision as written in that particular city. So basically, the definition that we recommended to go into Green's charter would be what the court would look at if there was a protest challenge to a candidacy's qualifications.
Mr. Helms?
4977 Maslin Road. I think there's two basic concerns of what the lawyer is doing. One is a general lawyer that's trying to take care of all the ills. The communication of the city. You don't have to be a specialist in municipal lawyering to be a good communicator and save the city a lot of money. Secondarily is one of the largest funds that the city has paid out in legal fees is to bonding lawyers, more so than to our own personal lawyers that we've had. So someone that's working as a general counsel for one of the big corporations actually has, for the city's sake, more qualities to save the city money than someone that works with laws and everything else. So what are we looking for? Are we looking for a good communicator? Or are we looking for a good bond agent? What's going to be the best for the city? And these things here, strictly on the level of must work for a government agency, not any other privacy, not as a defendant in fighting zillions of zoning code violations or anything else. Who's going to be the best quality? And I think that's up to the citizens to determine. And this is, it is restrictive. And it's going to cost the city money.
Thank you. Last call. Is there anyone here that wishes to speak to 2019 R64? Welcome, Mr. Mucklow.
Hello. David Mucklow, 4882 Mayfair Road. There's no doubt that this provision is more restrictive. It eliminates attorneys who participate in civil private practice from participating in this process. If you look at the language that has been presented to you, it's very narrow. It's not, as Vivian has described it, you have to read the language closely, and it's very restrictive, and it's a misrepresentation to keep telling people that it's opening the door broader. It's not. And it wasn't necessary to be that restrictive. They could have came up with a definition that was not that narrow. I think the real issue is, what it's doing is it's setting up a situation where you're not going to be able to have a qualified attorney down the road, and the mayor's going to appoint one. And that's what this is all about. It's an end run around issue 14, and it's disgraceful. And it reflects back to the people who sat on the commission, 2 people in particular, who were part of the anti-14 committee that defamed people who were responsible for putting this on the ballot. People like myself. I was called all kinds of defiling names that was totally uncalled for, and it did not add anything to the process, and it is a shame, and it's shameful. And these people should have never been put onto the commission, and it taints everything coming out of the commission being placed on the ballot. These issues are dead on arrival, and I don't see how any of the voters could ever support these 3 main contentious issues that are being forwarded to the ballot. And I would hope the citizens pay attention and shoot them down and vote no. Thank you.
Thank you. Anyone else? Then we'll move on to 2019 R65. A resolution to amend section 6.4D of the Charter of the City of Greene to provide for filling a vacancy in the Office of the Director of Law and declaring an emergency. Any members of council wish to speak to 2019 R65? Any members of the public wish to speak to 2019 R65? Before moving on, I would point out that the body of 2019 R65 indicates that in the event of a vacancy of the law director, it wouldn't be the mayor, but it would be city council that would fill that vacancy, just to address one of the issues that Mr. Mucklow set forward. So the mayor wouldn't be fulfilling a permanent vacancy if it occurred. 2019, which takes us to 2019
66.
R66. A resolution to amend section 8.3 of the Charter of the City of Greene to include a credit for income tax paid to multiple municipalities and/or to a joint economic development district and declaring an emergency. Again, I sat in on the meeting where this was discussed in painstaking detail. There was, it was late. I mean, it was probably 10 o'clock at night one night, and the commission was struggling with how do we better define the idea that if you pay a higher income tax to another municipality, you don't have to pay green income tax. And it was absolutely correct that the current language of our charter was unclear on this issue and difficult to grasp. And the amendment that you see here as a result of a lot of thought, a lot of contribution from different people, and I do think improves the language. Are there any member of council that wishes to speak to 2019 R66? Any member of the public that wishes to speak to this amendment? Then, with regard to 2019 R67, it's a resolution to amend section 9.1 of the Charter of Greene to expressly reserve to the city the right to dictate ballot language for all proposed charter amendments and declaring an emergency. Any member of council wish to speak to 2019 R67?
Mr. Chairman,
Yes, Mr. Dyer.
again, this is a, this issue, I think, is just fraught and is unnecessary. I think it's a solution in search of a problem. And, you know, I think going back to what Mr. Mucklow said about anti-14 folks, you know, several of them were concerned about the ballot language that was put on about issue 14. And Mr. Mallow and Mr. Meager actually put in print that that was a big problem. You know, on November 27th in the Beacon Journal, Mr. Mallow said it's unfortunate the ballot language only presented the basic question of electing a law director without supplying the voters the actual text of the initiative petition. Mr. Meager said in his letter to the editor on October 25th that do not let the simplistic ballot language fool you. The issue is that ballot language came from council. Here's the language that passed 7-0. All of us on council voted for this ballot language. Quote, Shall Article 6, Section 4 of the Charter of the City of Greene be amended to make the City of Greene's law director an elected position and require residency within the City of Greene? And here's how it appeared on the ballot. Shall Article 6, Section 4 of the Charter of the City of Greene be amended to make the City of Greene's law director an elected position and require that the law director be an elector of the City of Greene? Slight change, not a major change, not a substantive change at all in any way. Again, the issue, it passed 7-0. Everyone on this, even the 5 who opposed issue 14, voted to put that language on the ballot. And I don't remember anyone debating about whether that language was appropriate or made any sort of reference, made enough references to the actual language of the ballot issue. I don't know. I mean, this just seems like we're trying to relitigate 14 again with this because people didn't like the ballot language, and so we're going to take the take the Board of Elections out of this. You know, tonight is the All-Star game up in Cleveland, and you know there are 2 teams, and umpires call balls and strikes, and every team hates the umpires for calling bad balls and strikes from time to time. But I don't remember a single rule change suggestion that said that the manager of one of those teams should now call balls and strikes because we don't like the calls that the current umpires are making. That's what this does, because the city, one of the issues that the city had, and in fact it's the only issue that's been put out on issue 14 by the city on official statements, is that the ballot language created an untenable, and we heard it again tonight, an untenable conflict of interest, which the Walter Haverfield opinion we received and was released a few weeks ago said was actually not true. That was not the case. And yet here we are saying that the city isn't going to put something on the ballot that would be in any way sort of misleading, even though that is. So again, and the other issue is, you know, if let's just say council puts forward another ballot language that some folks don't like, they can petition to the Board of Elections before the Board of Elections puts it on to say change it. You could have changed it. You could have said, you could have told the Board of Elections, look, this is misleading. We should have more information on this, and you know that kind of stuff. And then the Board of Elections could have put on a different ballot issue. With this, you eliminate that possibility because the Board of Elections will now have to put on exactly what we give them. This, they changed a little bit, they tweaked it a little bit. But I don't understand, there is no problem here. The Board of Elections is bipartisan, they do great work, they are good umpires, they call balls and strikes. The last thing you want is most of these initiative petitions that are going to be coming before the voters are in reaction to something that those seeking the initiative didn't like that the city did. And now you're going to let the city determine what the ballot language is? I mean, that's not really fair. So again, I think that this is a really problematic thing. And I know that members of council spoke to the commission about our serious misgivings about this issue. And it's disappointing to see it on the ballot, on the list here.
One question, Mr. Dyer. Who drafted the issue 14 ballot language? Didn't that come from the Board of Elections?
No.
Who drafted it?
I wasn't even here. I was
Look
on
at
leave.
you, look at you.
I didn't think it was council. I thought it
came from the legislation.
I thought it came back from the Board of Elections, and I was under the impression we didn't have the right to alter it. But
That's right.
That's
we
actually
can
what we
speak
were
to that
told, I
issue
think.
in a minute.
Yeah, I just
Go
want to,
ahead.
add some clarifying points because the document that was distributed does not match the recommendation of the commission. So the recommendation of the commission is that council has the right, not that the city. So the argument that I'm hearing from you, Mr. Dyer, is actually not aligned with the recommendation that we made.
By city, I consider council part of the city.
Okay,
Yeah.
well, the language, the way that you described it is that somehow someone else, the mayor or other, would override what council proposed. And what we're saying here is, it doesn't say it has to be, but it says it could be. And to the point that Mr. Jurgen mentioned, during many, many hours of deliberation, one of the conversations that was presented is that it wasn't clear who wrote the language, and it wasn't clear that the council had the right to do this. And so the reason for adding it was to make that clarification and to give the clarity around the council's role in doing that, should they choose to. It's not dictating that you must, it's saying, should you choose to, you now have the right because it's been prescribed in our charter.
Anyone else on council?
Mr. Chairman.
Mr. Humphrey.
You know, facts on this matter. So first of all, Mr. Jurgen, you bring up a good point. The Board of Elections drafted the language. It was presented to council. We asked the question what our duty was, and our duty was basically to vote on it, which is why it was 7-0, even though I was against the issue, but I was told that it was my duty to basically, unless there was some obvious legal defect, that we had to forward it. So that's number one. Number two, you can't have it both ways. You can't keep saying, I want the voters to decide this. I think the voters deserve to have a say on this. I think the voters should be able to tell us what to do. And then to say, well, let's let the Board of Elections tell us what to do. I think in a city, we should have the right to be able to say, this is the ballot language. I, as a city council person, have a right to vote on that ballot language if that's in our charter, and I don't want to rely on somebody at the Board of Elections to do that. The people of the city of Greene have elected me to make those calls on the balls and strikes. That's why we're here. Why would we want to give up control to the Board of Elections, who is not elected to anything and can rarely agree on anything? Why would we ever want to cede that kind of control to them? So, first of all, the case is misstated, and second of all, I think the argument is misplaced, because if you want the voters to decide, their elected representatives have an opportunity to be able to say this is the ballot language, and if the voters don't like the decision that the council makes, they can replace the council. That's how a democracy works.
Mr. Chairman,
Mr. Shaughnessy, please.
I would like to say, yes, the case has been misstated. It's not the voters that choose the ballot language, it's the Board of Elections. Now, an initiative, and we're talking here on 2019-68, it's very similar to 67. I want to address 68, it's the initiative. An initiative is the people's tool. It's for the people to address a concern that its elected leaders are not addressing. They go out with a concern, they put it on an initiative, on a petition, and they get their signatures, and they want it to go in front of the ballot. They can rely on the Board of Elections to draft a fair ballot language. Now, here we are, the city, the council, and we want to control that ballot language. I don't think we should have any business putting our hands on that scale.
Anyone else on council?
May I ask a question of Mr. Shaughnessy? Mr. Shaughnessy, I understand your point, but what if you have somebody that they draft an initiative petition, they get signatures on it because it's popular, but when we go to our legal counsel, they say there's a couple problems with it. It violates the Ohio Constitution, it violates the United States Constitution, and it violates the charter of the city of Greene. Is it our duty as elected officials then to just put our hands over our eyes and say, it violates all of those things, but we're going to allow it to go to the voters even though it could never be enacted in law? Is that operating under the duty that we have to support the Constitution and the charter?
That there is a false option. Obviously, no. Your duty then is to inform the public and tell them what you think. But it's not to change the ballot language. It's to make your argument to the public. And in many ways, you've already done it with issue 14. The city issued a legal opinion with regard to issue 14 saying that it created an unmanageable conflict of interest. They put that on their website. And then we later found out there is no unmanageable conflict of interest, yet that opinion still sits on the website until tomorrow maybe.
When I take an oath of office to serve as a city council person, I swear an oath to uphold the laws, the Constitution of the United States and the state of Ohio. If I put before the voters, talk about a false choice, if I put something before them that is clearly unconstitutional and violative of the law, then I have just violated my oath of office by allowing that to go. To me, even though it may be distasteful to say, this is not something that I want to have my hands in because enough voters signed the petition, I would be violating my oath of office to put that in front of the voters because it's something that violates all the three things that I said that as a council person I would uphold.
Thank you, Mr. Humphrey. I just will quickly respond. If the voters propose something that's unconstitutional, the courts will throw that out. It's that simple.
Mr. Spade?
Thank you, Mr. Chairman. You know, the way I look at it is this amendment as well as 10.1, which deals with initiatives, and the one with the referendums. The way I look at it is if there's an initiative or a referendum, that means that the public does not like something we did on city council. And therefore, they probably don't want our input when it comes to the ballot language. It is, I understand it may be our legal authority to adjust the ballot language, but it's not our moral authority to dictate the way something reads when people are making a decision at the ballot box. I've seen some misleading ballot language before. We had it with the changing the primary date. There was some bad language that was written in there. We made that decision up here. However, the Board of Elections, that's their job. Let's let them do their job, and let's let the residents, if they want to put forth a petition for an initiative or a referendum, they should be able to do that unhindered by city council. You know, I think I have a different definition. To me, I have a different definition of what my job is as a public servant, and that is to act at the will of the people. If the will of the people is to put something on the ballot, we should do that. Thanks.
Any other members before we go back to commission members?
Yeah, Mr. Yergin, just something real quick. I mean, the reason that people go out and get initiative petitions and do these things is because they don't like what the city is doing or they want to change something. And so, of course, the city or the, you know, administration or the council or whatever isn't going to like what is coming before them. Because if they did like it, they would have written the legislation themselves. So now you're giving the agency against whom the people have a grievance the right to determine the language on the ballot, which Mr. Meager and Mr. Mallow admitted may have had an impact on whether issue 14 passed. So you're having the group that's being criticized tilting the playing field. And I just think, you know, we've already got the umpires. We don't need to change them out for the managers. That's all. Sorry to use that reference again.
Can I ask a question?
Yes, Ms.
Just for
Babbitt.
a point of clarity. I didn't see issue 14, or I wouldn't see any referendum like that as passing judgment on council. That was passing judgment on how our charter was structured and how we, you know, put a law director in place. So I don't see the conflict there, is what I'm saying. Like, I don't think every initiative or referendum is directed at an act of council. So that's kind of the, I'm trying to really think this one through and understand where everyone's coming from on this, but I don't think that's always the case, that it is that they're trying to correct something that we've done. In this case, they were trying to correct our charter, I think. I mean, at the end of the day, maybe it had something to do with how it worked with the mayor appointing a law director and how they felt that all worked out, but it was fundamentally a charter issue. So I think in a case like that, it's not wrong to allow council to work on the language or pass on it to make sure that it's clear. I don't have the trust that you have in the Board of Elections, and I'm to anyone out there on the Board of Elections or involved, I'm sorry to, say that, but I think you could go to different communities across the board and hear a different argument on this. And you might find that the people who came up with the referendum or the initiative or whatever the case may be didn't like the language that the Board of Elections chose. Do you know what I'm saying? Like, I think what they're trying to do here is add another layer to pass on it.
I don't disagree with you, Barb. What I'm saying, though, is that, just like in baseball, we're going to disagree with some umpire calls from time to time, and people are going to get thrown out of games even, suspended, whatever. But you don't change the umps, and you don't change out the umps for the managers, for somebody who clearly has an interest in one of the outcomes or the other. You want somebody who is basically a disinterested party coming up with the language as they see it. And so I think that that's a much better protection for democracy, frankly, than to have people who have a vested interest in the outcome determining what it looks like. That's all I'm.
I
that's all I'm
promise I
trying to
won't
say.
belabor this anymore, but one way of looking at this could be, though, that if council is allowed to have the input that something like this would give council over that language, that the interests of the people who want that on the ballot might be better represented than having the Board of Elections responsible for the language?
Well,
And we should continue to move on. The hour's getting late. One thought, and then we'll go back to the audience, but the thing about the Board of Elections is, my dealings with them is they're probably the most political place in Summit County. I mean, when you go there, everyone identifies themselves as a Democrat or Republican. You're very conscious of that when you deal with them. There's a political electricity about the place. To me, the question is, do you want politicians who are not responsible to the people making ballot language? Or do you want folks who are directly responsible to the people making that ballot language? Because ultimately, that's the argument that Mr. Dyer had presented for issue 14. Is it better to have a law director who is answerable to the people, or one that is not? And it seems to me his argument for the elected law director applies here with equal force. Do we want people that are answerable to the people, determining that language? I think that the commission was wise in that they did not make the language mandatory, so that council can look at any particular ballot or initiative and say, you know what, in this case, it's not appropriate that we determine the language. And they could, in the right circumstance, elect to punt and give it to the Board of Elections. There are other situations where, because we don't have a crystal ball, it would be appropriate for council. So I think ultimately this is a question, again, for the voters. Do you want to give your elected officials who are responsible to you the opportunity, not the mandatory obligation, but the opportunity to determine ballot language on these issues?
Mr. Real quick, not to disagree with you in public, but the Ohio Revised Code says that boards of elections, that's their purview. Just like on state issues, it's there's a state board of, I forget the exact name, but all the issues come out of that state board, and people say this language should be like this language should be like this. The board determines what it is, and they're made up equal parts, the Democrats and Republicans. Again, the reason that the Ohio Revised Code puts it in the hands of the Board of Elections is to get it out of the interested party status. So if there are, and I know, Mr. Chris, it's very funny, but if there are people who are, if there's a referendum or an initiative or something like that, the Board of Elections, is the best agency to come in from the outside without a dog in the hunt, picking the ballot language. And then you can go to the Board of Elections and you can say, I think it should be like this, and the other side says, I think it should be like this, and the Board of Elections figures out a way. I don't understand why we want to do this, other than the fact that those who are opposed to issue 14 did not like the ballot language, and I just can't divorce myself from that reality that one of the main reasons that those who did not like issue 14 thought it passed was because of misleading ballot language, and this is their attempt to undo that. I can't divorce myself from that.
Mr.
from what
Chairman?
happened.
Yes, Mr. Mr. Humphrey.
Isn't it interesting as we create this bogeyman of people who were opposed to issue 14, when the issue came before council, even though I believe at that time there was probably a majority of council that disagreed with issue 14, we were adults and did our duty and passed along the ballot language that was given to us, and we didn't alter it one iota. So to say that elected officials can't do the responsible thing and use it in the context of issue 14 is the best argument to prove you wrong, because that's exactly what we did. So to keep using that is
Board of Elections
misleading.
told you what to put on, Chris.
Well, I think we should move on. Mr. Meager, please.
Just a couple clarificating, because I mean, it's very important to use technical language here. This 9.1 and 10.1 don't apply to referendums at all. It's initiatives. So this idea that council is going to be.
I apologize for misspeaking. I did not mean referendum.
And you're not the only one to use it. I just want to make sure it's clear for everyone else. The second thing I want to point out
Although
is.
it was under consideration, wasn't it? Referendum.
I mean, I don't know if it was. I knew it was not going to be part of it for what we voted on. There's a lot of discussions that came out just for the sake of discussing it. The second thing I want to point out is according to the Ohio Secretary of State's handbook, you have to have it in your charter, council's ability to dictate ballot language, or you can't dictate ballot language. Here's the exact quote. The exception to the board's elections authority regarding ballot language for local questions and issues is the rare case of a charter that reserves to the city, village, or county the right to dictate ballot language for questions or issues submitted to the electorate in accordance with the charter. So without this language in there, you can't dictate ballot language. You can't go against what the Board of Elections said. And let me ask this to the council here. Did you know at the time that language was proposed to you on issue 14 that you could change the language? And if you knew that, would you change it? Can I get a show of hands who would change that?
I think we would have considered it if we knew it were an option.
Yes, and without this in the charter, you don't have an option to do that. That's the intent of this. This is not about issue 14.
What's the authority on that?
Chapter 1 of the Ohio Secretary of State's handbook.
Yeah, but what's the section of the Ohio Revised Code or the Ohio Administrative Code that they're citing that says you can do that in your charter?
I mean, I can do some research, but this is coming straight from the Ohio Secretary of State's charter handbook. So that's just my point. We're reserving to council the ability to dictate this language. You guys did not know you can change the language. This gives you the ability to change it if you want to. Without this, you can't do it. That's the whole point of this. This isn't something to go against issue 14. Issue 14 raised the issue, and then my discussions with council members like, I didn't know I can change the language. This gives you authority to do that. That's the whole intent of 9.1 and 10.1.
Thank you. Other members of the public? Ms. Stoynoff?
Katie Stoynoff, 235 Lakefront Drive. Again, here I'm not representing my position in Green School Board. I'm here as an electorate. These are two bad amendments. This is frankly ridiculous. The reason why you shouldn't change the language is because what Mr. Humphrey admitted, which he was against it. So if you're going to change the language, there's no guarantee that you're going to change it to fair and accurate language. The job of the Board of Elections, bipartisan job of the Board of Elections, is to set ballot language, and they should do their job. This is the equivalent of letting a horrible employee write their own performance review. Of course it's going to be glowing. Initiatives do sometimes address things that council or other parts of the city have done. And if you read what it says it gives it to the city. Now, you may have to pass it, but that doesn't mean that the city itself couldn't have input on that. I think this is horrible. I think it spits in the face of the community and the electors to have a say and address their government when they think the government's out of line. If you guys don't like it, and when I say you guys, it may not be you, it may be other people. If council doesn't like what someone's doing, it says it has to be fair and accurate, but the other problem is, just like I pointed out with the idea of the who's going to enforce it, somebody has to go to court. So a person takes time to craft an initiative, they take time to get the signatures, and then council can set the agenda as what the ballot language is. What does that person do if they don't like it? then they're going to have to go to court because the ballot language was manipulated by a body who was the subject potentially of that initiative. I mean, it just smells of conflict of interest, and it is, frankly, sour grapes from the issue 14 thing, period. And it's really, like, I suspect some of what's going on in 6.4, but I'm frankly angry about what is going on here because it is obscene, period.
Ms. Dufferin.
Vivian Dufferin again. I have a copy of this board's, this body's ordinance 2018-20, which approved, which recited the language of the initiative petition. But in the end, in section 3, the only part that's relevant to the people voting that day, this city council said that it is the desire and request of this council that the ballot for said question be substantially in the following form. Proposed charter amendment, City of Green. Shall Article 6, Section 4 of the Charter of City of Green be amended to make the City of Green's law director an elected position and require residency within the City of Green, yes or no? That's essentially what we all saw when we went to the ballot. Not the rest of this language, not the rest of this initiative petition that we are now having to live with in our charter. So council is already recommending language to the Board of Elections. And for the most part, with issue 14, the Board of Elections adopted almost that very language. So it is something that you're already doing. Thank you.
Mr. Helms?
(4977) Maslin Road. I've done at least 12 petitions, charter amendments and initiative petitions. We have the right, as the people, to actually put the language we want in the petition if we want to make it a little extra wordy. Most people aren't going to read it. So we usually don't because we trust the Board of Elections. But if we wanted to, we could propose it. Now, the Board of Elections, if we put it in our petition, could only change it if there's a good reason. As it presently happens with the Board of Elections usually doing it, if we want to object, we can go to court. Very simple. There's a very fast procedure. If you guys write it, which you actually have the option, once we submit it to you, you have the option to write your proposal. Both proposals can go to the Board of Elections, and they can choose between the two of them and put them together. But you're mandating only you, and guess what? My experience, it's impossible to sue you. So, this just restricts the hell out of everything. Sorry. If I fight anything in my whole life, I'll fight this one. Excuse me, I'm talking about R67 and R68. Thank you for your time.
Anyone else on R67?
First of all, this language offends me. No one's going to dictate to me what I can or cannot do. I know the intent, but the language is offensive. I object to that in one way. Anybody who is sitting up here that thinks politics doesn't play into this, please come down from your ivory tower and see what's going on. This is such a politically divided city, you can determine what's going to happen just by knowing what people, who's behind it, who's for it, who's against it. You know what's going to happen. I may not be politically correct saying that. Nobody may like to say that. We are a bipartisan city. You can't say you're a Republican or a Democrat when you vote for it, but by golly, everybody knows who's on whose side. The PACs come out, the literature comes out, you know. All right, so that's a given. I was under the assumption that if you have certain language on a petition, a couple things happens. That's the language that the people read to put their signature on that petition to say, yes, I like it, or no, I don't. No one has the right to change that language after the vote. How do you do that? You're going to say, okay, the language in this is not correct. We, the city, are going to change the language that you, the people, voted on. How do you do that? You rewalk the petitions, saying, okay, now this is the issue you're talking about. That's impossible. You can't do that. Just like you can't take your name off or you can't add names to a petition once they're turned in. Sitting back there and listening to this frustrates me because it is so political. So, and it has been from the very beginning. It has been from the very beginning when this was proposed as a charter change. People were vilified, names were called, people were evil, and it happened at every friggin' meeting. That something would be said that these people that believe in this, they're not good. They don't represent our city, and something should be done about it. Well, you know what? Bring back the pillories, and maybe we could burn them at the stake. Because you're always gonna have it in this city, always. And any of you that have been around know, you know it. You may be afraid to say it. I've run into people, I've run into people that told me, Linda, I agree with you, but I'll never admit to it. During an election, they tell me that. It's like, fine, I'll give you money, but I'm to support you, but don't put my name on anything. I don't want anybody to know I'm behind you. Is that the way to do it? No. And I agree. This is like taking the fox to watch the hen house. Exactly. You do your work, then you bring it to the people that you're saying, we need a change. Now, you tell us if we're right. You tell us if you're going to allow us to do it. Don't dictate to me. This is a republic. This is a democracy. You don't dictate. Maybe the wording needs to be looked at. Maybe something should be said that the city will take into advisement or will suggest or don't dictate. I mean, that's crossed the line right there. So good luck on the decisions.
Thank you. I don't want to leave anyone out, but the hour is getting late and we need to move on. Last call for 2019 R67.
Mr. Chairman,
Yes.
I think it is worth pointing out after the former councilwoman's comments that a lot of us wanted to see the exact language that had been on the petition put on the ballot. So actually what you're saying kind of plays back into some of the concerns some of us have about wanting council input, because to me, that language that we got from the Board of Elections on this issue was not what should have been there. It should have been exactly what the people signed on to. So I hear what you're saying, but the way that we have it going now with the Board of Elections assigning us the language isn't making that happen either. So do we have a better chance of that happening with council having approval over the language, or should we look at another direction? Because what you're saying isn't happening with what we have in place now either, unfortunately.
Mr. Yergin, perhaps one more thing that we could check through our outside legal counsel is how many municipalities reserve this right to dictate ballot language? I'd like to know.
Moving on to 2019 R69, a resolution to amend section, we're in 2019 R68, a resolution to amend section 10.1 of the Charter of the City of Greene to provide the city expressly reserves the right to dictate ballot language for all proposed initiative issues and declaring an emergency. The conversation on R67 basically spilled over into this. I think we've heard an awful lot on these issues that are very similar. I guess I'd like to continue to move on, but want to give folks the opportunity if they're dying to say something in regard to this that hasn't been said. We'll let council do that. Anyone in the public that really needs to speak to this issue on something that hasn't already been said? Mr. Helms.
The law director is an elected position. We have a procedure for any elected officer called recall. This adds an extra provision where you guys can get rid of our elected position. Why?
That's our 69-year.
That's the next one.
That's the
R69, what
next
do you
one.
want? I'm sorry.
We're on 68.
R68.
Forgive me, but that's all I was gonna say on 69. Sorry.
Okay.
Come back for that.
Hold that thought. Moving on to 2019 R69, a resolution to amend section 12.8 of the Charter of the City of Greene to provide for the removal of the Director of Law and declaring an emergency. Opening this up first to members of council. Anyone have any thoughts about our 2019 R69? Hearing none. We'll now open it up to members of the public. Any member of the public, Mr. Helms, do you wish to speak to 2019 R69 at this time? Mr. Helms, do you wish to speak to this? Okay, all right.
That's what I said. Let's say it again.
4977 Maslin Road, R69. Basically, it's elected official. We have the ability to recall, as we can recall all of you guys. We don't need you being able to recall our elected official. I don't think this is necessary. It's just, it's restrictive. If our elected law director does something that the people wants and you guys don't like it, why should you have really the right to remove him? Simple as that. Thank you.
Mr. Mager?
I think the intention from this was just for some parity, because this section applies to removal for other directors or officials, including elected officials. So we thought it'd be important to have language in there that talks about appointing special counsel, because otherwise the director of law would be presiding over his or her own removal. So that was the thought process, adding a provision that says, okay, if you're trying to remove the director of law, that person cannot be presiding over their own removal. It has to be somebody else. That's the whole intention of that section.
Mr. Chairman, I
Yes,
think there
Mr.
just
Dyer.
might be some confusion. This is, if you're thinking on the federal level, this is sort of like impeachment. Not quite, but sort of like impeachment. So yes, there's recall, but this is a different kind of process. I don't think it's ever been used. But directors can be removed through this process. The problem is the directors would, those I guess trials you would call them, I don't know what you call them, but those procedures would be overseen by the director of law. It seems silly to have the director of law overseeing their own procedure. So I think that's the issue. This is already in there for every director. It's just carving out the director of law because now they're elected and all that. Am I accurate on that?
Yes. Any other member of council wish to speak to this issue? Any member of the public? Then I think we have gone through all of the charter amendments. Ms. Capello, am I correct on that? Have we read them all in?
Yes,
They've all
I
been
checked
thoroughly
them all.
discussed. I appreciate the robust discussion for tonight's proceeding. There was a lot of disagreement, but that's what democracy's about. I appreciate everyone's being respectful, their contribution, and I think this was a healthy discussion. Again, I want to thank the Charter Review Commission for their hard work. I think that you guys did an amazing job, and there weren't very many people that came to some of the meetings, and I think that it could have even been better if we had more public comment while the meetings were happening. But your job was done very well, and again, I want to thank you for your efforts. With that, the public meeting on, I'm not going to read all the numbers again, but all of the charter review amendments is adjourned.
Very good. Thank you, Mr. Yergin. You did a fine job. We'll move on to this council meeting. That takes us to the reading of correspondence.
Email from Dennis Meneval regarding speeding on Jarvis Road. Press release from Eileen Shapiro regarding appointment of Diane Miller-Dawson, and an email from Jerry and Teresa Moon regarding Mayfair East lighting. And that is it on that.
Thank you, Ms. Capeluk. That takes us to the reading of new legislation.
First reading 2019 R70, a resolution authorizing the funds to enable the mayor to grant salary adjustments to City of Green non-bargaining employees and declaring an emergency.
This will be referred to the Rules and Personnel Committee.
First reading ordinance 2019 R71, a resolution amending the City of Green compensation system by updating the salary range schedule for non-bargaining unit employees and declaring an emergency.
This will be referred to the Rules and Personnel Committee.
First reading resolution 2019 R72, a resolution adopting the Summit County Emergency Management Agency multi-jurisdictional hazard mitigation plan and declaring an emergency.
This will be referred to the Intergovernmental and Utilities Committee.
Mr. President.
Mr. Dyer.
We've had a request from the administration to pass this on first reading because to be part of this emergency management agency, plan. We need to pass this by July 31st, and we're not going to have another meeting before then. And we discussed this in committee, and there was no objection to passing it on first reading. So with that, I would move that we bypass committee deliberations on 2019 R72.
Second?
I have a motion and a second to bypass committee deliberations on 2019 R72. Is there any discussion? All in favor?
Aye.
Opposed? Motion carries.
I would move that we bypass the three reading rule on 2019 R72.
Second?
I have a motion and a second to bypass the three reading rule on 2019 R72. Is there any discussion? All in favor?
Aye.
Opposed? Motion carries.
I'd move that we adopt 2019 R72.
Second?
I have a motion and a second to adopt 2019 R72. Is there any discussion? Will the clerk please call the roll?
Mr. Dyer,
Yes.
Mr. Humphrey,
Yes.
Mr. Shaughnessy,
Yes.
Mr. Spate,
Yes.
Mr. Yergin,
Yes.
Mr. Young,
Yes.
Mrs. Babbitt.
Yes.
Resolution 2019 R72 adopted 7-0. First reading ordinance 2019-15, an ordinance changing the zoning classification of property containing approximately 13.6 acres of land located at the southeast corner of Maslin Road and Wise Road from R1 Single Family Residential to PD Plan Development, and approximately 5.1 acres of land from B1 General Business to PD Plan Development, and approximately 1 acres of land from B3 Neighborhood Business to PD Plan Development, and accepting a conceptual site plan of the proposed New Seasons Plan Development.
This will be referred to the Planning and Economic Development Committee.
That's it?
That's it. Okay, that takes to the report of council committees. The first committee to report this evening is the Finance Committee, chaired this evening by Mr. Humphrey.
Thank you, Mr. President. Finance did meet this evening. We had a second reading of 2019 R53, a resolution authorizing the City of Green to enter into a contract with American Structure Point for professional engineering services for the Maslin Road and Bettler Road roundabout, making an appropriation and declaring an emergency. The total amount of additional appropriation for this is $8,748. This is the second reading, and the committee requests time.
Time will be granted.
We had a second reading of 2019 R54, resolution authorizing the City of Green to enter into a contract with American Structure Point Incorporated for professional engineering services for the Maslin Road and Corporate Woods Circle roundabout, making an appropriation and declaring an emergency. Money was previously appropriated for this, but we need to create a separate fund so that we can track the costs and expenses associated with this particular roundabout. So the amount that was appropriated before is $340,000. We are unappropriating that. We are appropriating the $348,300 to the appropriate fund so that we can track these expenses. This is the second reading, and the committee requests time.
Time will be granted.
We had a second reading of 2019 R55, a resolution approving a final change order for the increase in the Lockhart Concrete contract for the 2018 miscellaneous concrete repairs project and declaring an emergency. After we got into a couple of these concrete repair projects, it turned out that the base of some of the concrete that was needing to be replaced also needed work, and so we had a couple of change orders that increased the cost of the project by 13%, and so this legislation allows that those change orders to be approved and paid. Again, this is the second reading, and committee requests time.
Time will be granted.
We then adjourned at 5:12, but then we reopened the committee so that we could give the tax administrator's report for the second quarter. For the second quarter, we're up 11.32% when we compare last second quarter to this second quarter, and when we compare 6 months of 2018 compared to the first 6 months of 2019, we are trending ahead by 6.35%. These are all positive trends, and we're grateful for it. We had no other items of old or new business, and we adjourned at 5:49.
Thank you, Mr. Humphrey. The next committee to report is Environment and Parks, chaired by Mr. Spate.
Thank you, Mr. President. Myself, Mrs. Babbitt, and Mr. Shaughnessy were here. We did not have any items of legislative business, new or old business, therefore we did not meet.
Thank you, Mr. Spade. The next committee to report is Public Safety, chaired this evening by Mrs. Babbitt.
Thank you, Mr. President. Mr. Humphrey, Mr. Dyer, and I were all present. We did meet this evening to consider a license item, TMP 2681, approval of the D5, J, and D6 liquor license transfer from Chop and Swizzle to ELG Pizza, LLC, DBA DeLuca's Pizza Pub, at 3700 Maslin Road, Suite 220. The Summit County Sheriff reported that they had had no issues at that address with that liquor license. There was no discussion on the matter, and we agreed that at this time, I will move that we do not request a hearing on TMP 2681.
Second?
I have a motion and a second not to request a hearing on TMP 2681. Will the clerk please call the roll?
Mrs. Babbitt,
Yes.
Mr. Humphrey,
Yes.
Mr. Shaughnessy,
Yes.
Mr. Spate,
Yes.
Mr. Yeargin,
Yes.
Mr. Young,
Yes.
Mr. Dyer.
Yes.
Okay, we had no other items of business, and it seemed like we were adjourned a week ago, but it was actually 5:13 this evening.
Thank you, Mrs. Babbitt. The next committee to report is the Planning, Community, and Economic Development Committee, chaired this evening by Mr. Yeargin.
Thank you, Mr. President. Myself, Mr. Spade, and Mr. Young were present. We had several items of legislation before us. One was an old item, 2019-04. It's an issue that we can continue to do research and development on, and that's an ordinance establishing public notification relating to the master trail plan. Because that continues to be a work in progress, we're going to ask for time.
Time will be granted.
Actually, fourth reading was 2019-R44, a resolution amending the conceptual site plan of the Bayside Investments Plan Development District, now known as Forest Lake Subdivision Plan Development, located between the north end of Tabbs Drive and Interstate 77, and declaring an emergency. A public hearing was held on this legislation on June 25. It has been discussed on second and third reading, and it is now time to move to adopt 2019-R44.
Second.
I have a motion and a second to adopt 2019-R44. Is there any discussion? Will the clerk please call the roll?
Mr. Yeargin,
Yes.
Mr. Spate,
Yes.
Mr. Young,
Yes.
Mrs. Babbitt,
Yes.
Mr. Dyer,
Yes.
Mr. Humphrey,
Yes.
Mr. Shaughnessy.
Yes.
Resolution 2019-R44 adopted 7-0.
On third reading, there were two items. 2019-R13 is an ordinance declaring a portion of improvements to a certain parcel of real property owned by Cam Green 2 LLC to be a public purpose, exempting 100% of the value of the improvements from real property taxation, requiring the owners of those parcels to make service payments in lieu of taxes equal to the real property tax, the depositing of those service payments in the appropriate fund, and providing for the payment of a portion of said service payments to the Green Local School District for 30 years and declaring an emergency. This is a third reading item. It's been discussed the last two meetings. Mr. Weathy has explained that the school district superintendent and treasurer have been advised and are on board, and in light of those things, I move to adopt 2019-13.
Second.
I have a motion and a second to adopt 2019-13. Is there any discussion? Will the clerk please call the roll?
Mr. Yeargin,
Yes.
Mr. Spate,
Yes.
Mr. Young,
Yes.
Mrs. Babbitt,
Yes.
Mr. Dyer,
Yes.
Mr. Humphrey,
Yes.
Mr. Shaughnessy.
Yes.
Ordinance 2019-13 adopted 7-0.
The final matter before us tonight in this committee is 2019-14, an ordinance declaring a portion of improvements to a certain parcel of real property owned by Freddy's Ohio LLC to be a public purpose, exempting 100% of the value of the improvements from real property taxation, requiring the owners of those parcels to make service payments in lieu of taxes equal to the real property tax, the depositing of those service payments in the appropriate fund, and providing for the payment of a portion of said service payments to the Green Local School District for 30 years and declaring an emergency. Like 2913, this is a TIF that has been discussed the last two meetings and has also been presented to officials for the school district. In light of those things, I move to adopt 2019-14.
Second?
I have a motion and a second to adopt 2019 R14. Is there any discussion? Will the clerk please call the roll?
Mr. Yergin.
Yes.
Mr. Spate.
Yes.
Mr. Young.
Yes.
Mrs. Babbitt.
Yes.
Mr. Dyer.
Yes.
Mr. Humphrey.
Yes.
Mr.
Yes.
Shaughnessy.
Right to it.
I'm sorry.
I
yes.
wasn't going to forget you. Ordinance 2019-14 adopted 7-0.
That is the end of the list of legislation that was before the Planning and Economic Development Committee. There was no old or new business raised in that committee, and the committee was adjourned some time ago.
Thank you, Mr. Yergin. The next committee to report is my committee, Rules and Personnel, chaired by myself. Mr. Dyer and Mr. Humphrey were present. We had one third reading item, 2019 R46 as amended. A resolution authorizing the mayor to enter into a contract with Roderick, Litton, and Belfance LLP to provide Director of Law Services to the City of Greene and declaring an emergency. This item was discussed, so at this time I'll make a motion to adopt 2019 R46 as amended.
Second?
I have a motion and a second to adopt 2019 R46 as amended. Is there any discussion?
Mr. President?
Mr. Dyer.
Quick. I think this is this legislation, I think, is a really good example of us all working together to fix an issue that's out there. Addressing this issue of interim law directors and interim directors or whatever, I think, is something that the Charter Review Commission recognized that we needed to do. And I wanted to commend Mrs. Babbitt, Mr. Yergin, and everyone else on council for working with and the mayor for working with us to make this work. And to Mr. Chris for providing a new contract so that we can all start fresh and move on. Again, this was the result of the unprecedented issue of having an elected law director issue before the people. What do you do with the appointed law director in the interim? And now I think we've got a nice way forward. And, you know, I know we catch a lot of grief on council for dissension, but I think this is a fine example of us working together to for the people of Greene, and I'm glad that we all did it.
Is there any other discussion? I have a motion and a second. Will the clerk please call the roll?
Mr. Dyer.
Yes.
Mr.
Should've started with
Young.
him.
Gee.
I know. Mr. Young.
We
Mr.
had to
Dyer.
change our- There's a
Mr.
difference.
Young.
Yes.
Mr. Dyer.
Yes.
Mr. Humphrey.
Yes.
Mr. Shaughnessy.
Yes.
Mr. Spate.
Yes.
Mr. Yergin.
Yes.
Mrs. Babbitt.
Yes.
Resolution 2019 R46 adopted 7-0 as amended.
Very good. We had no other business. We are adjourned at 5:26. The next committee to meet or to report is Transportation, Connectivity, and Stormwater, chaired this evening by Mr. Shaughnessy.
Thank you, Mr. President. Myself, Mr. Young, and Mr. Yergin were present. We had one item on the agenda. It's the third reading item. 2019 R47, a resolution allowing the mayor to apply for federal congestion mitigation air quality funds program by the Akron Metropolitan Area Transportation Study for the Arlington Road Reconstruction Project and declaring an emergency. This is for future improvement and widening of South Arlington Road just south of 619 to Bettler. Our preliminary project estimate is $10 million, and if awarded a grant, we could receive up to $6 million with as little as 20% match. This is a third reading, so at this time I move to adopt 2019 R47.
Second. I have a motion and a second to adopt 2019 R47. Is there any discussion? Will the clerk please call the roll?
Mr. Shaughnessy.
Yes.
Mr. Dyer.
Yes.
Mr. Humphrey.
It's late.
Yes.
I get it.
Yeah, I'm gonna get you all somehow. Mr. Spate.
Yes.
Mr. Yergin.
Yes.
Mr. Young.
Yeah.
Mrs. Babbitt.
Yes.
Did I get everybody? All right. Resolution 2019 R47 adopted 7-0.
Having no other business to discuss, we adjourned at 5:27.
Thank you, Mr. Shaughnessy. The next committee to report is the Intergovernmental and Utilities Committee, chaired by Mr. Dyer.
Thank you, Mr. President. Today we had a couple of items on the agenda. The first is a third reading of 2019 R51, a resolution declaring the necessity to make improvements to the street lighting system for Mayfair East subdivision phases 1, 2, and 3, assessing the cost of the improvements to the property owners within the subdivision and declaring an emergency. Mr. Humphrey, do you want to recuse from this, or?
Yeah, well, I think since I have before, I'm
Okay.
not going to be discussing it. So
Okay.
as I stated before, I've recused myself and I'll abstain from voting based on that recusal.
Okay. I thought that the public hearing on this issue would set the record, but I was clearly wrong from last meeting. But the issue is there are a lot of streetlights that are going out in Mayfair East, and we need to make it a street lighting district so they can go in and make upgrades to their system. We heard from many folks from the subdivision, and they were here tonight, and they were okay with moving ahead with the legislation as currently before us. And so given that, I would move that we adopt 2019 R51.
Second.
I have a motion and a second to adopt 2019 R51. Is there any discussion? Will the clerk please call the roll?
Mr. Dyer.
Yes.
Mr. Shaughnessy.
Yes.
Mr. Spate.
Yes.
Mr. Yergin.
Yes.
Mr. Young.
Yes.
Mrs. Babbitt.
Yes.
Mr. Humphrey.
Abstain.
Resolution 2019 R51 adopted 6-0.
Also before us was 2019-12, an ordinance approving a petition for special assessments for special energy improvement projects and a plan for public improvements, approving the necessity of acquiring, constructing, and improving certain public improvements in the City of Greene in cooperation with the Akron-Summit County Energy Special Improvement District, determining to proceed with such project and determining to levy special assessments in connection with such project and declaring an emergency. This is another issue we discussed at last meeting regarding our entrance into a special energy improvement district for, in conjunction with Summit County. Summit County's trying to go around and collect everybody into these districts, and what they do is they allow local businesses to access grant funding and other financing to put in energy improvements, so new lights, new roofs, those kinds of things. This would essentially allow the County of Summit to finance about a $400 light bulb replacement project on one of their properties in Greene. But in conjunction with that, they can set up this district so that then anybody else in the City of Greene who wants to apply for these things doesn't have to jump through that hoop. This is kind of doing them a favor before they have to go through the joy that is bureaucracy. So anyway, with that, this is on third reading. I move that we adopt 2019-12.
Second.
I have a motion and a second to adopt 2019-12. Is there any discussion? Will the clerk please call the roll?
Mr. Dyer.
Yes.
Mr. Shaughnessy.
Yes.
Mr. Spate.
Yes.
Mr. Yergin.
Yes.
Mr. Young.
Yes.
Mrs. Babbitt.
Yes.
Mr. Humphrey.
Yes.
Ordinance 2019-12 adopted 7-0.
We also had a brief discussion about 2019 R72, which we just passed on first reading. It was our inclusion into the mitigation phase of emergency management, the county's emergency management plan. We needed to pass that before July 31st, and since we're about to go on vacation for a couple of weeks, it wouldn't be possible to meet that deadline unless we passed it tonight, so that's what we did. And then we adjourned at approximately, yesterday? Something like that.
Thank you, Mr. Dyer. The next and last committee to report is the Charter Amendment Implementation Committee, chaired this evening by Mr. Yergin.
Thank you, Mr. President. Myself, Ms. Babbitt, and Mr. Shaughnessy were present. We had several items, to say the least, before us tonight. One was 2019 R52, which we discussed in committee. It's a resolution to amend the appropriate articles and sections of the Charter of the City of Greene relating to the non-substantive changes throughout the Charter per Charter Section 12.10, Charter corrections, and declaring an emergency. The non-substantive changes had to do with form over substance, of course. They had to do with typographical errors, changing the gender of pronouns, and making words consistent. There was very little discussion because it really was a housekeeping matter. It's on second reading, so we'll ask for time with regard to 2019 R52.
Time will be granted.
With regard to all the rest, number 2019 R56 through R69. Those were the subject of an extensive public meeting just a few minutes ago, public hearing, and were read into the record at that time. Because there was a public hearing, we don't have the option of voting on them tonight. It's my understanding that we must vote on them by the second meeting of August. We could do it as early as the first meeting of August, but must do it by the second meeting of August. Having already read those in, I'm not going to do it at this time. There was no other matters, old or new, before the committee, and the committee adjourned many hours ago.
Thank you, Mr. Yergin. That takes us to the mayor's report.
Thank you, Mr. President. Starting back on June 29th, speaking of a long time ago, was Freedom Fest here in the city of Greene. I want to thank Valerie Carr for her efforts and the park division. You guys did a great job. It was a great event for our city. The next day, on Sunday, June 30th, I attended the first of 3 community conversations called Your Voice, Ohio. This is a collaborative effort of more than 50 Ohio news outlets, newspapers, radio, and television, setting aside competition to listen to Ohioans and better represent them in local, state, and federal democratic practices. The reason I mention this is because their next meeting will be next Wednesday, July 17th, from 6 to 8 p.m. at Greensburg United Methodist Church, and they encourage you to sign up ahead of time so they know how many are coming. On July 4th, Greene hosted our first community 5K at Raintree Golf and Event Center. So once again, a very nice event. Valerie, thank you for your cooperation, and thank you to Rocco Yergin, who jogged along at my very slow pace through the 5K. So thank you, Rocco.
And Pam Serena, who placed.
And Pam Serena, who won an award, our Human Resource Director.
Oh, she laughed. I thought she was still here.
I was told that next year I can win an award because I'm shifting up to the next age class where there is only two participants. So we'll see about that.
If they change it to speed walking mayor, you'll definitely win an award.
Oh, thank you, Rocco. You're so kind. Over the last week, the City of Greene hosted the mayor of our sister city from Bayoush, Romania, Petru Melendia-Kalus, and his wife, Gabriella, who is a dentist/oral surgeon. And so we toured the city of Greene, first starting with Greene local schools, but since she was a dental expert, we also visited Spoonhauer Orthodontics and Town Crossing Dental, which are 2 very new dental facilities in our city. For her interest, other events included Cleveland Clinic, Akron General Health and Wellness, Akron Canton Airport, Akron Children's Hospital, Gables of Greene, YMCA City Parks, and Raintree Golf and Event Center, and more than a few of our fine restaurants. Some upcoming events. First of all, today, 619 was closed at Myersville Road for construction of the intersection. That will be closed through August 20th, and hopefully the weather will hold up and we'll get through that before school starts. That's certainly the goal. Also want to note that there's going to be some free Narcan training and Narcan kits provided at Fire Station number 1 over the next couple weeks. Those half-hour training sessions will be this Thursday, July 11th at 5:30 at Fire Station number 1, and again on Thursday, July 18th, again at 5:30. This coming Saturday, July 13th, is the city's Electronic Recycling Day from 9 to noon at the Greene Highway Building in Greene. This is for residents only, and a proof of residency is required. And you can see the city's website for items that will be accepted. On Wednesday, July 17th, we'll be hosting Planet Green series, and this one is called Attracting Beneficial Insects to the Home Garden Habitat. Now, I must comment that we don't get a lot of people coming to these events, but the people who come find them to be fantastic. So I don't know how to rectify that other than to keep announcing them and hoping people find an interest and come. That event will be, again, July 17th at 7 p.m. at Central Park Community Hall. Admission is free. And then on Thursday, July 18th, will be the next packing for Blessings in a Backpack. This will be one of the summer packings, and that will start at 9 a.m., although I encourage you to get there about 8:45 because they always start early. Saturday, July 20th, will be the next Live After 5 event in our community. These are band concerts at Central Park. Admission is always free. Live After 5 certainly would indicate that it starts at 5 o'clock to 11 o'clock. This band will be Overboard, which they say is the Love Boat Band. I'm not sure what that means, but that's what it is. Thursday, July 25th, Green Drug Task Force will be hosting a Community of First Responders launch party. with a performance by country artist Shane Runyon. This concert is also free. It'll start at 6:30 to 9 p.m. at Central Park. Admission is free, and once again, this is to highlight the importance of treatment and recovery programs for those who are addicted to heroin and other drugs. And finally, the last thing, Thursday, August 8th, will be a public meeting on capital improvements budgets for 2020. All council people are encouraged to attend, as well as residents from our city. You're welcome to attend and make suggestions for things on the CIP. That will be at 9 a.m. in council chambers, once again, that Thursday, August 8th. That's all I have, Mr. President.
Thank you, Mr. Mayor. Is there any unfinished or new business?
Move to adjourn.
Mo-
Announce your vacation.
We are adjourned.
Visitor.
Yeah, we announced it first of the year.
Thank you. Yeah, just sit there.
We just throw these in your car.